Yes, Wayne County Jail. Good morning, ladies and gentlemen.
Morning, Your Honor.
Good
Good morning, Judge.
Mr. McWilliams, you're here on Hurley.
That's correct, Your Honor.
John, I just watched the roll call. I literally just watched it.
Do I have an APA here on Hurley?
That's awesome. Just the second for the jail.
Okay, Mr. McWilliams, I'm gonna have to come back to you. We don't have an APA here for you yet.
That's okay. I'll be standing by, Judge. Thank you.
All right, thank you. Mr. Deaver.
Morning, Your Honor.
Sir, what can I do for you? You here on Hood, Martez Hood?
Yes. I think my name on this Zoom thing is incorrect, but I'm here, Martez Hood.
No problem.
Thank you.
Case number 2405-845301 was State Michigan versus Martez Hood. Defendant is charged in count 1, assault with a dangerous weapon, count 2, domestic violence.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the People, P number 60249.
Good morning, Ronald Deeble, P63897, on behalf of Martez Hood, who I'm not sure is here or not.
He's here.
Okay.
Introduce yourself and tell us your name, sir.
Good morning, Martez Hood.
And what's your pleasure, Mr. Deaver?
We'd like to have a separate preliminary exam, please.
We'll continue the plea of not guilty. We'll set this matter for preliminary examination. How is August 7th at 9 o'clock?
We have anything on the 8th, maybe? I have a few other matters on the 7th.
No, sir, that's my homicide day.
Oh, all right. Can we do it a little later on the 7th? Maybe 10?
You do August 7th at 10:15.
Okay, let's take that. Thank you, Your Honor.
We continue if there's no objection.
No objection, Your Honor.
Thank you, Your Honor.
Mr. Hood, that'll be August 7th at 10:15 in 36th District Court. That's in person.
Good morning.
In person.
Yes, sir.
And I heard that my charges were assault with a deadly weapon.
Count 1, assault with a dangerous weapon, count 2, domestic violence.
Okay, I got a question about that.
Ask your attorney, sir.
Okay.
I'll call you later, Mr. Hood. Okay, I have your number and I'll call you later. If you don't mind, 313-407-7259.
One more time, please.
313-407-7259. 3659. I'll be busy, but call me later after 3, okay?
All right, I will.
Thanks.
Thank you.
Ms. Broughton,
Good morning, Judge.
good morning. What can I do for you?
Your Honor, I'm here for PCC on Marcus Butler.
Okay. Great, but
It's right there. Remember, that's the one they asked us to. Change, don't-
oh no, this is. You're here on, we have two buttons. You're here on Marcus Butler or Breon Butler.
Marcus Butler, Your Honor.
it's right.
Oh, okay.
Ms. Broden is the prosecutor.
All right. Ms. Broden, we're waiting on Ms. Brandon to show up.
Thank you, Judge. And I couldn't rename myself, so I'm sorry. I think the court may need to rename me.
You're okay.
Thank you.
Hey, Mr. Bella is here now. I think he may be here on Hurley. Is that right, Mr. Bella?
Yes, Your Honor.
Okay, we're gonna recall Hurley.
Morning, John.
Good
Morning.
morning, John.
Calling case number 2405-843401. People of the state of Michigan versus Donald Curl. Defendant is charged in count 1, homicide, murder, second degree. Count 2, weapons, felony firearm.
I go back to August.
Here, just for the record, please.
Good morning, Your Honor. John Bell on behalf of the people, P68673.
Morning, Your Honor. Attorney John McWilliams, P 17565.
What's your question, Mr. McWilliams?
In-person preliminary examination, and if August the 8th would be available, I think I would be ready for it along with my client.
You're waiving your client's appearance for purposes
I
of this hearing?
don't see him on, but I will convey that to him and instruct him directly. He probably will be in custody.
The court waived the defendant's presence, continue to plea of not guilty, and set this matter for preliminary examination. August 8th at 10 o'clock.
That's perfect, Judge. Thank you very much.
Mr. Bella?
Yes, Your Honor, you said at August 8th at 10 o'clock?
Yes, sir.
That works for me. Thank you very much, Your Honor.
And I acknowledge that I did receive from Mr. Vella the discovery package. I haven't downloaded it yet, but I will directly.
Sir, in the Wayne County Jail, what's your name?
Marcus, good morning, Your Honor. My name is Marcus Butler.
Your Marcus Butler. Just wait on your attorney to get here, Mr. Butler.
554-3767.
Are we all set, Your Honor?
Yes, sir. Thank you.
Very good. Thank you very much. Have a good day.
You too.
Thank you.
Today's docket. Next court date is August 7th at 10:30 in person. Oh, okay. Oh, August 7th.
Good morning, Ms. Barnwell. Ms. Barnwell?
Yeah, I'm here on Jonathan Seeley for
Is that you,
PCC.
Ms. Wilmot?
Pardon?
Good morning, Your Honor. Yes, that's, can you hear me?
Yes, I can hear you.
Oh, okay, yes, that's me.
Okay, we're ready to speak.
Go for it. Thank you.
Calling case number 2.
Now my headset. I always use my headset. Oh,
Case number 2405 84401.
that's all.
Michigan versus Jonathan Seeley. Defendant is charged in count 1, criminal sexual conduct first degree. Count 2, computers using to commit a crime. Count 3, children distributing sexually explicit visual or verbal matter to.
Appearances for the record, please.
Good morning, Your Honor. Erin Wilmoth, P 82085, appearing on behalf of the people.
Mute yourself, Ms. Barnwell. There you go.
Good morning, Your Honor. Wendy Barnwell, P42505. On behalf of Mr. Jonathan Seeley, I'll eventually need a breakout room with him, but for right now, we're gonna ask for an exam.
All right, Mr. Seeley, tell me your name for the record.
Jonathan Seeley.
All right, the court will continue the plea of not guilty. We'll set this matter for preliminary examination. How is, how's August 9th at 10 o'clock?
I'm in a trial I'm in jury selection on that day in Ann Arbor. 1 second.
I'm actually finishing a bench trial that's in progress, that has actually been in progress for a year and a half, if you believe it. And we are finally finishing it that Friday at 10 a.m.
How's August 12th at 10 o'clock?
I started jury trial.
Well, Ms. Wilmoth, I'm not sure if we're gonna be able to do this then.
I can propose the 16th, the Friday, the 16th, like later on in the morning.
We can try that, and if I'm done with trial, I will handle it, and if not, I suppose I will have to try to find someone to cover for me. If we could do sometime later in the morning or early afternoon on that Friday, the 16th. My schedule, sorry, Judge, is bad.
August 16th at 11 o'clock.
Yes, that's good.
Sure, and I'm gonna send a protective order over to the court for signature today so that I can get Miss Barnwell the kids talk along with the rest of the digital discovery in this case.
And I also need like paper. I was looking for it. I didn't see it.
I'll make sure you have everything, Miss Barnwell.
Okay, thank you so much. And Judge, can you put me in a breakout room? Thank you, Erin.
Are we all set, Your Honor?
Yes.
Have a nice day. Thank you.
Thank you, you too.
Same to you, Erin. I'll talk to you in a breakout room now, Mr. Seeley.
All right.
Go ahead and join. Ms. Franklin, good morning.
Good morning, Your Honor. How are you?
Good, and yourself? You're here on Marcus Butler?
I am, Your Honor, and I'm well. Thank you for asking. He is in custody, and I am willing to waive his appearance for today's proceedings. I have seen him in jail.
Okay, let me call him.
Call in case number 2405-835-401. People of the state of Michigan versus Marcus Butler. Defendant is charged in count 1 and 2, criminal sexual conduct, first degree. Count 3, kidnapping. Count 4, carjacking. Count 5, robbery armed. Count 6, assault with a dangerous weapon. Count 7 through 12, weapons, felony, firearm.
Appearances for the record, please.
Good morning, Your Honor. Grace Burton appearing on behalf of the people, P80298.
And good morning, Your Honor. Attorney Kiana Franulik, P73015, on behalf of Mr. Marcus Butler. Mr. Butler is in Wayne County Jail. I will waive his appearance for today's proceedings. I have spoken with him regarding this matter.
And Your Honor, I believe he was there. I apologize, Your Honor. I believe we did see him on Zoom today.
He was here, but he's not here now. The court waived the defendant's presence. What's your pleasure?
Your Honor, requesting preliminary examination in this matter.
And the court will continue the plea of not guilty. We'll set this matter for preliminary exam. How is August 9th at 10 o'clock?
I have an evidentiary motion that morning. I have a motion hearing that morning, but I should be done by 11, or I can do the afternoon.
Same, Your Honor. I have a few hearings in the morning, but I'm available the afternoon of the 9th.
August 9th at 12 o'clock?
That works for me, Your Honor.
That works for the people, Judge. Thank you very much.
All right, August 9th at 12 o'clock, bond will be continued.
Thank you,
Thank you, Your Honor.
Mr. Washington, what can I do for you?
Yeah, good morning, Your Honor. I have I think it's Breon Butler.
Okay. Yes.
Case number 2405-845401. People of the state of Michigan versus Breon Butler. Defendant is charged in count 1, assault with intent to do great bodily harm, less than murder or by strangulation. Count 2, assault with a dangerous weapon. Count 3, weapons, felony, firearm. Count 4, domestic violence.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning, Your Honor. Earl Washington, Neighborhood Defender Service, P31383, on behalf of Mr. Breon Butler. I don't see him in the gallery, but I can waive his appearance.
I'm sorry, say that again, Mr. Washington.
Yeah, I don't see Mr. Butler, but I can waive his appearance.
The court will waive the defendant's presence. What's your question?
Judge, I would request a preliminary examination date.
Court will continue to plead not guilty and set this matter for preliminary examination. House August 9th at 10 o'clock.
10 o'clock. That looks good.
August 9th at 10 o'clock, and bond will be continued.
Okay. Thank you, Your Honor.
Thank you.
Have a good day.
Thank you. You too. Yes, ma'am. Can I help you?
Hi, I'm the juvenile probation officer for Marcus Butler.
Okay, what can I do for you?
I wanted to view his hearing for today.
And you have to view these hearings on YouTube, but we did, you said, which one, Marcus Butler?
Yes,
We set Marcus Butler for August 9th at 12 o'clock.
August
For
9th.
For preliminary examination, yes. So you either have to come in person to see it or view it on YouTube.
Okay, thank you. You said August 9th, 12 o'clock. I'll be there in person. Thank you.
Thank you. Ms. Chambers,
Yes,
can I help you?
I've been here for court.
What's your name?
Nigel. Oh, Marcus.
You don't know your name?
Oh, Nigel.
Your name is Nigel?
Yes.
Nigel Chambers? I don't have you on my docket, Nigel Chambers.
No, I've been here for court.
For your case?
No. My kid's father case.
And your kid's father's name is what?
Marcus Butler.
Okay, so we did his case already. It's set for preliminary examination on August 9th at 12 o'clock in 36th District Court for preliminary examination. You either have to view it on YouTube or come in person.
You said it's August 9th?
Yes, August 9th at 12 o'clock.
Okay, thank you.
Good morning, can I help you? Wayne County Jail Division 1 Cam 2.
Yes, sir. We can't start our video, sir.
And what are you here on?
It's Mr. Marcus Butler for PCC.
Okay, we did it already. It's August 9th at 12 o'clock. For preliminary examination. Did you get that?
Noon at for exam.
I'm sorry?
Do I have it right, Your Honor?
August 9th at 12 o'clock.
Yes, sir.
Yes.
Thank you, sir. That's all we had.
All right, thank you. Have a good day.
You too.
What's this on the iPhone?
Davita Reed.
What can I do for you, ma'am?
I'm the victim of the case with Marquise Butler. I was told to come in here if I wanted to.
Okay, so matter you said for Marcus Butler? It's
Yes,
scheduled
sir.
scheduled for August 9th at 12 o'clock. That's at 36th District Court. You have to come in person on that day.
Okay, August 9th at what time?
12 o'clock.
Okay, thank you.
All right, thank you.
Okay.
Yes, sir. Mr. Banks,
Yes,
where are you at, sir?
in placement.
You're supposed to be here in person for your preliminary exam.
Uh, I didn't know that because I'm in placement right now, but
What facility are you in?
Spectrum. Me and my case manager said if I had it in person, then nobody let her know, but she said if I had it in person, they could transfer me here to there. What time do I have to be there?
It's supposed to be 10 o'clock.
Uh, I don't know. Can I call my mom and tell her, do my mom gotta be there too?
Not necessarily.
I'm sitting here with what did you say, sir?
You're the defendant. You're supposed to be here. How old are you?
I'm 16. But they was confused. My case manager was confused because they didn't know if it supposed to been in person or not in person. I'm sitting here with I forgot what it is.
Good morning, sir.
Hey, good morning. Yes, he's supposed to be here in person for his preliminary examination at 10 o'clock.
Yeah, we were not sure about that. I could see what I can do, sir, but for them to transfer them down there, it's only 9:25 a.m.
Okay, if you can get him here, that'd be great.
But if he cannot get in there, can he still do it over Zoom, sir?
No, it can't be by Zoom. He has to be in person.
But let me see what I can quickly put together, sir.
Okay, thank you.
You're welcome, sir. Yeah.
That's all. Okay. All right, I'll let them know. All right. Push downstairs.
Okay, the sergeant called me, on the Moody's case. Wayne County, Painting. He asked me to ask you, can you just ask him anything, paperwork to his email for this Moody guy, because you know, that's the one they got to go to the nursing home and get all that. So he just called me and asked me if I could ask you to text him some paperwork, because he said he been telling the guys, but they ain't really responding, so he wanted to do something right, I guess.
Okay, I think the name, email, yes, email.
H. Wilson. At Wayne County, Michigan, .gov. Thank you. What's his name? Is Movie something? What you saying?
Gotcha. They didn't bring over, our juvenile.
10 o'clock?
So I just resubmitted the writ to Sergeant Green to let him know we need him in person.
He in juvenile? See if I got that number, let's make something happen. With juvie.
Four 35 just got phone.
Hey, sorry, was just KT, man. I took care of that. I was calling you, I have to have another for juvenile. Do you need to contact juvenile? This person over here.
He said he was in some kind of place. Spectrum.
That's 0773. Okay, thanks. Yeah. Yeah, hey, how you doing? I need to speak with Sergeant Green or either Sergeant Miller, somebody, we need a prisoner over here that's at 36th District Court. This is Officer Taylor. Yes, this is KT. Yes. What's up, brother? You all right? I'm good, man. Trying to hold it down. Yeah. You know Sergeant Green? Yeah, I got another cell phone. I just tell some. I gotta get somebody. I gotta get somebody to get this person over here, man. Okay. Yeah. Give me her. Okay. 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 Thanks, man. I appreciate it, Will. All right, brother. You take care, man. All right. Oh, Sergeant Miller. Sergeant Miller. Hey, how you doing, Sergeant? You all right? Uh, this KT, man. We need a prisoner, man. That they're not bringing him. He's a juvenile, and we need him over here like ASAP. I don't know. I don't contact them. He was a juvenile, so he had juvie. So that's probably where the ball got dropped at. His last name is Banks. First name J. First name Jay
Inspection.
Are. No, he's a juvie, so I guess he had.
He said he had spectrum.
He had spectrum. Oh, my judge, hey, sorry, Miller. So my judge said he's at Spectrum.
And we sent the a writ.
And we sent the writ. But yeah, well, she's been sending writ, so she sent it to the normal person she sent it to.
So he didn't say send to him and to the juvenile writ email.
Listen, he was supposed to be here at 10, so I need you to expedite this, Sarge, please. All right, Sarge, I took care of you, so now it's time to return the favor. I took care of you when I worked for you, right? All right, thanks, Sarge. Okay. Hey, call me back. Let me know what's going on. Oh, I'm so sorry. Sorry about that.
Oh, who you know, KT?
Yes, sir. That was my ex-boss. I told him, didn't I used to take care of you? Yeah, so take care of me. Now I'm over here. What is Spectrum? That's I ain't up on that. What that's the type.
He said he was in placement, so.
Okay, yeah, they got all kind of programs. Also rebar. Hey, what they say? I'm not sure. The clerk stepped away. I'm not sure where she sent it. Well, she told me she just sent another writ. She sent them another one in case they lost it. This is like her second writ. This morning. She sent one before this morning. Well, man, but you know, we press for time. We need that guy. Okay. Right. Well, when she come back, I'm gonna find out where she sent it and I'll call you right back. I saw it.
They can't find the writ.
Yeah, that's what he said that where did she send it to? If she sent it to transport, she should have sent it to juvenile. That's what he said.
I think that's what she said. She said.
Yeah. So I told him I'm waiting on her to come back so I can give him exactly where she sent it.
Tim.
This guy, man, he, 10 o'clock, county, got it, right? Ain't nobody getting over here.
Juvenile didn't bring them over here.
Yeah.
They always do it.
Yeah.
You already got the phone call?
Yeah. I'm on.
Did they get the written?
That's what, wait, they come back. They say they didn't get the written, but she said she told me she should have another.
They do it every time. They do it every time.
Trying to get that together.
Yes, sir. Hey, look, Ronell Bachelor, need principal. On the paperwork. So. You downstairs, you should be in class. Oh. It's probably not. All right.
Sorry, say you said CT or you said.
I sent it to the juvenile writ email that they told me all juvenile writs go to.
They claim, of course, they claim they can't find it.
That's okay. I sent it in
To the same one?
to the same one, which is Sergeant Green. The writ, their default email.
Trying to get your client. Trying to get your client. Oh, okay.
I can't remember the name of the scene. Every time, every time I go over there, I get some runaround.
He zoomed in this morning and said he
Hold on,
was inspection.
sorry.
Pardon me?
He zoomed in this morning and said he was inspection.
I sent it to the juvenile.
See, I was told he was in Cali.
Email with the Sergeant Green told me.
That was a few weeks ago.
That's where we initially had to write them out for the arraignment
Can you
judge was
send it to
Calumet. So since then, I don't know, has he been transferred? I have no idea.
It appears that way.
Oh, okay.
We're working on it.
Okay, that was my most recent, was when we had talked about.
Right.
Do something, okay. Okay.
Where's it?
Right.
Oh, is it?
Oh, Spectrum Health. I'm sorry, Spectrum Health.
Oh.
issues with any of the surveys.
Okay. Okay.
I mean, I guess software.
Sorry. The courtroom.
The code of conduct
Three,
was
nine,
saying,
six,
no, we
five.
adjourn.
Two.
Yeah,
Two,
hold
two.
on, I gotta step, like, catch up.
Eight,
Who's
three.
judge is that? Who's that?
Yeah.
Right.
Yeah.
I couldn't remember.
Arnita. Arnita. T-A-J. Reynolds. Yes. Yes. Judge King. Judge King.
How many minutes is it?
Just one.
Oh.
Yeah.
Not like last time, Judge.
Okay. All right. All right, bye.
So he said he owned it, right?
I'm trying to contact them. and see what's going on.
You got the number of spectrum. Let me see that. Let me see a piece of paper. Right there. Yeah, let's do. Okay, you got a
In
number.
May, I don't know, day I got a civil trial, supposed to start Monday.
Yeah, that's right, John. Yeah,
Some corporate actions.
She on the phone.
Excuse me, I need you. Do you know what spectrum is?
No, that's like me. No, that's all. No. Nineteen sixty-one.
Yeah, my little.
Thank you. Okay. Also, he's in transit, that's for sure. So your guys are gonna, you know, how long before they left, we wait on. Okay, perfect. Thank you so much. Where you guys located?
Hey, Jackson, I'm Junior, I'm over.
Yeah.
Fingerprint. Thank you.
There you go.
Wayne County don't transfer from Spectrum, that's their own transportation, but he's en route. He's en route, he should, it's in Highland Park, so it should be a day, it's left, appreciate it. Okay, so he's en route.
Okay, so now what about that other matter?
The movie.
Do you know if the guy got the?
Oh, I'll call him, I'll
Okay.
call him. Yeah, I'll call him.
Oh, so they got him en route to come here? Great. Yes.
Yes. Okay, so not an officer. All right. All right.
That's true.
Yes, sir. Come up for a second. How you doing? Oh, yes. Yeah.
scan.
Okay.
Thank you.
So. I was kind of surprised. I was kind of surprised that the show. Listen.
Singleton. Yeah. All right.
Yes, sir. Okay. Okay. Oh, yeah.
Lock up, you see it, but they have a problem getting the drinks off of it.
Yeah, they got somebody going down there already to try to, maintenance dude, try to, fix it already.
Yeah, but they might not have a good key down there.
What she said.
Okay.
You can fix it.
Yeah, I'll go down there. I'm gonna check it out, man.
Yes.
I'll go ahead and stand next to you. Sit next to you. Yeah. 36, or 3624.
Zaire Banks.
Yes.
Calling case 2457766, people of the state of Michigan versus Jair Banks, and discharged in count 1, homicide, murder, first degree premeditated, juvenile defendant. Count 2, homicide, felony murder, juvenile defendant. Count 3, assault with intent to murder. Appearances for the record.
Good morning, Your Honor. My name is James Kehoe. My PIN number is 82812.
Good morning, Your Honor. My name is Ben Gunning. My bar number is P43716, and I represent Mr. Banks.
Tell me your name, sir.
J.R. Banks.
There's the date and time set for preliminary examination. Are we ready to proceed?
Yes, Your Honor.
Yes, sir.
And I believe the people say they have one witness, right?
Yes, Your Honor.
Have any preliminary matters before you party witness?
Just a couple, Your Honor. First, I believe for exam purposes only, there's going to be a stipulation as to the identification of the deceased, Mr. Jerry Adams.
So stipulated for exam purposes.
That's correct.
Court received that stipulation.
Second, Your Honor, this time I move for the admission of proposed exhibit number 1, which is the medical examiner's report as it pertains to Mr. Adams.
So stipulated.
Court received that stipulation and admitted.
Your Honor, may I publish a copy of the report?
Yes. Thank you, sir.
Can I just read a portion of that into the record, Your Honor?
Yes.
This is from ME case number 23-15649 by Dr. Lokman Sung on Tyrese Adams back on December 20th, 2023. It's my opinion that death was caused by multiple gunshot wounds. There were 3 gunshot wounds present on the body, 2 to the head and 1 to the right shoulder. There was gunpowder stippling noted on the skin surrounding GSW number 1. And then perforating gunshot wound to the head labeled GSW number 1. There was a through and through close range entrance gunshot wound above the left eyebrow with faint gunpowder stippling involving the skin of the left eye and upper left cheek. Wound track proceeded through the left frontal bone, left frontal lobe of the brain, brainstem, right cerebellum, right occipital bone, and ended at an exit wound on the right occipital scalp. Wound track was from front to back, left to right, and downward. Perforating gunshot wound to the face, GSW number 2. There was a grazed gunshot wound around midline of the inferior tip of the nose. Wound track continued into the right upper lip, fractured multiple teeth, and ended as a tangential exit gunshot wound on the right angle of the mouth. The wound track was from front to back, left to right, and downward. A deformed bullet jacket fragment was recovered from within the mouth and retained. Perforating gunshot wound to the right shoulder, labeled GSW number 3. There was a through and through entrance gunshot wound on the anterior right deltoid. Wound track proceeded through the soft tissue on the right upper arm and ended in an exit wound on the posterior right deltoid. The wound track was from front to back, slightly left to right, and slightly downward. A deformed bullet jacket fragment was recovered from within the right shoulder and retained. The manner of death is homicide, and that was signed by Dr. Sung on February 15th of this year, 2022. And Your Honor, I have no further preliminary matters.
Okay, call you.
At this time, we call Tyrell Adams. So stand. I guess, Judge, I should ask for a mutual word of sequestration with the exception of the officer in charge.
Ladies and gentlemen in the audience, if you are a witness or potential witness, I'm ordering you to step into the hallway to further on the circuit. Give your spelling to the young lady seated there. Give me your name and spelling. Please raise your right hand, sir. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Can't hear you. Yeah. Thank you. Please have a seat there. Speaking to that microphone that to your left, that has the white on it. There you go.
Can you hear me?
Yes.
All right.
When you're ready.
All right.
Thank you. Mr. Adams, could you just state your name for the record, please, sir?
Tyrell Adams.
Thank you, sir. I'm going to draw your attention back to December 20th, 2023 at the address of 14958 Lavin Street, okay?
Okay.
What were you doing at that location?
It was in a house.
What kind of house was it?
It was a trap house.
And what were you doing at the trap house?
It was in there chilling.
I'm sorry?
It was in there chilling.
You were in there chilling? Were you doing anything else besides chilling there?
No, nothing else.
Were you selling that day?
You said what I'm selling?
Yes.
No.
What about boy and girl?
I mean, yeah, but that wasn't me.
Okay, was someone there selling with you?
Yeah,
Who was that?
my brother,
And what was your brother's name?
Tyrese Adams.
Okay. When that day starts, who all's with you at the 11th Street address?
It was me, Riz, Sleeves, Love.
Before the incident, I want to talk about that, but before the incident, who was there? Remember no swearing, remember? No swearing, right?
Yeah, right.
Okay, so who was there before the incident happened?
It was just me, my brother, and Riz.
Okay. And how do you know Riz?
I knew him because he was around.
How long have you seen Riz around?
I'm gonna say for a year.
For about a year?
Yeah.
And you say he's around, what do you guys do when Riz is around?
He was just sitting around trying to get some money with.
Okay, when you say sitting around trying to get money, was he there at the house with you?
Yeah.
Anywhere else that you and Riz and your brother would hang out?
Nah, my brother didn't even know.
Okay, so
No, my brother.
okay, so you knew Riz from hanging around on Lavin?
Yeah.
Okay, silly question, but what city is Lavin Street in?
Detroit.
And you referred to Risk and you kind of nodded your head to him. Do you see Risk in the courtroom today?
Yeah.
Well, hold on. So at the time of this incident, did you know Risk's real name?
JR.
And do you see JR in the courtroom?
Yeah, right over there.
So you're pointing to your right. Could you just identify an article of clothing that he's wearing and say where he's seated in the courtroom?
He wearing a blue sweater. And he over there next to his attorney.
Your Honor, may the record reflect identification of the defendant in this matter?
So noted.
So at first, you indicated that it's you, Risk, and your brother. Is that fair?
Right.
Okay. What happens next?
While we here, it was less than 300 parked outside, like across the street.
Okay. Could you tell us who was in the 300?
No, I didn't know till they came in the house when they was outside.
So there's a 300 parked across the street, and then what happens next?
They will, the 300, well, hold on. Cause you getting mixed up. My brother, when the 300 was outside, my brother opened up the door for Riz.
Okay, so I'll stop you there. Let's make sure we get the timeline right, okay? So first, it's just you and your brother, correct?
Right.
And then you said that your brother opens the door.
Right, that's when the 300 was across the street here.
Okay, who comes in the front door?
Riz.
Does anyone come in with Risk at this point?
Nah.
Okay. So at this point, it's you, your brother, and Risk, fair?
Right.
For about how long is it just the three of you in the house?
Well, I'm saying we in there for like 5 minutes, 6.
Okay. What are you guys doing for those 5-6 minutes?
Yeah, we just got, we in there chilling. Riz coming there, when he came in, he just got to send some bull with them.
Okay, without swearing.
No swearing.
What did he say without swearing?
Well, I object, Your Honor. I mean, if I watched
preliminary examination before, and I know the issues the prosecutor's trying to address. But if there were words said by parties there, I think those words should be testified to, not his interpretation of it.
I was just trying to cut down the swearing, Judge, but I'll get the direct quote, that's fine. I think it's right.
Yeah, I mean, it's okay if he says, if they swore, that's okay.
Okay.
Yeah.
Tell exactly what.
No, I understand the concern, from watching or reading the last exam.
Thank you. So, what did he say exactly, Mr. Adams, and you can swear?
All right, I'm asking like, why you here? He's saying like, we just riding through, and I just told him put up here type thing.
Okay. After you have this exchange with Frisk, what happens next?
Now I just told him I just told him you got a dick. I'll let him back out. Sleeves the low trying to come in.
So hold on. So you said he tried to go back out?
Yeah, I told him he got to go. So I'm letting him out.
Okay, so you let him out, and then what happens?
Extra sleeves and low trying to come in.
Okay, where did they try to come in then?
Side down.
Okay, who was at the side door?
Like outside or inside?
Inside.
Me and Rich.
Okay. What happens after they try to come in?
When they try to come in, when they try to come in, I let them in and jump. It was all in there.
Okay, so you let him in?
All right. All right.
Had you talked to Lowe or Sleaze at this point?
No, never.
So Lowe and Sleaze come in. And you said you had never talked to them before?
No, I never talked to him before.
Had you ever seen your brother with these two individuals before?
Nah, he don't know none. He don't know none.
He doesn't know them?
Nah, none.
You said none of them, all right. I just want to make sure to speak clearly, okay?
All right, I'm trying to put the mic on.
You can put it on your lap, Mr. Adams.
All right.
Is that better?
Yeah.
Okay. So at this point, there's the 5 of you in the house, is that fair?
All right.
Where do you guys go?
No, now we in the living room.
You're in the living room?
All right.
Okay. What happens next in the living room?
While we in the living room, I let him in, we walked up, we in the living room now, Lotus was clutching, he cheated up on me.
Hold up, you're speaking so loud that the,
My bad.
1 second. Thank you. So let's try this again. What happens next in the living room?
All right, so Lo was clutching, he up on me and my brother.
When you say he's clutching, what does it mean to you when you say he's clutching?
And he told me gun.
He's got a gun?
Yeah.
And then you said he upped on you and your brother. What does that mean?
Like he pulled it out and put it on us.
Okay. What happens next?
Then he talking about where the payback.
Where the paper's at?
Yeah, where the money at.
Okay. Did you tell him?
No, I didn't know what he was talking about.
What happens after he asks you where the paper's at?
After he asked me where the paper at, he told us to go down the basement. So we down the basement, risking sleeves upstairs, trying to look for the money.
Stop. So he tells you you're in the basement and this is low, correct?
All right.
Okay. What do you see Risk and Sleeves doing?
That's when we upstairs. So by the time we downstairs now, so I get my opinion, they up there looking for the money. Whatever they look for.
But just to be clear, you can't see them while they're upstairs.
All right.
Okay. How long are you, and where's your brother when you're going downstairs?
My brother with me down the basement.
Okay, so it's you, Lo, and your brother downstairs?
Yeah.
How long are you, Lo, and your brother downstairs?
I'm gonna say for like good 5 minutes.
Okay. What's going on during that 5 minutes that it's you, Lo, and your brother?
All right, now that's when he told us to come up those stairs.
Who's he?
Lo, he told us to come up those stairs.
Okay. Did you go upstairs?
No, I take that back. Sleeves came downstairs and said we gotta go upstairs. That's when we brought us back up. Now we upstairs.
So hold on. So I just want to be clear. So at first it's you, Lo, and your brother.
Right.
Okay. And then Sleeves comes downstairs?
Right, he came back again.
Okay. And then Sleeves is the one that says to come upstairs.
All right, because he came downstairs and grabbed us when we go upstairs, not back upstairs.
Okay, so at that point, all 4 of you go upstairs?
All right, fine.
When you say 5, what's risk downstairs too?
Nah, you're right.
Well, I'm asking you, I wasn't there.
I guess what?
Okay. So the 4 of you go upstairs now. What happens next?
All right, now they can't find the money, so now they finna leave out. So while they finna leave out, they still had the gun pointing at my brother by the door. I'm about to I'm on the other side. I'm on the couch side, like on the other side of the couch. So then when they finna leave out, they walking back this way. So when they leaving out this way, they leaving out. My brother by the door. Really, I'm in the low. That's when he still clutching his gun, had his gun on my brother. That's when he let up a shot.
Hold up. Saying a lot, okay?
My bad.
It's okay. About how far are you from your brother at this point?
I'm like, I ain't that far. I can see what's going on.
Right, but were you about, from me to you, were you closer or further?
I was like right there, or probably like a little closer, like right there.
So how about right back here? You said that?
Yeah, like come up a little closer, right there.
Okay.
Right.
About 8 feet, Mr. Gonick?
Yes.
You indicated that the couch was between the 2 of you?
No, the couch, it's a couch right, it's a couch right here, it's a couch on this side.
Okay. But the couches weren't between you.
Right, it was between us, it was in the back, it was out the way, it was in the way.
Okay. You indicate at this point that Lowe still has the gun pointed at you?
Yeah, he don't got pointed at me, they can leave, he got pointed on my brother now.
Gotcha, okay, that's my bad. What's Risk doing at this point?
Rick, he talking to me about he laughing and everything goofy.
I'm sorry?
He laughed and think everything funny.
Okay. Did he say anything
No, he didn't say nothing.
at that point?
Nah, he just wanted to record.
What do you mean by record?
Like record the shots going on. That's the only thing he did.
What is he recording with?
His phone, a phone.
What's he recording?
And just the shots.
Well, before the shots, what did Risk say?
He didn't say nothing.
Are you sure?
I'm positive.
Remember testifying about this previously?
Hold on. If I ain't mistaken, hold on. No, he didn't say nothing.
So you remember testifying about this previously?
Yeah, you talk about what you trying to say?
Well, I'm asking you about what Risk says.
Yeah, when he said shooter?
Yeah.
Yeah.
Well, I'm asking you, what did Risk say?
Oh, he said shooter.
When did he say shoot?
When they finna leave out, he got the gun. He's like shooting. That's when the shots started going on.
Okay. Have there been any shooting prior to Risk saying?
Nah.
Okay. Did you, besides Lowe, how many firearms did you see?
One.
And that's just Lowe's?
All right.
And I know he said to shoot, but what were his exact words?
Like Rich telling love.
Yeah.
He was like, man, fuck it, shoot these niggas.
They say shoot or something else?
Man, he said, fuck it, shoot these niggas, man.
And what happened after the first time they gunshot?
You said the first one?
I'm sorry?
You said the first shot?
How many?
I heard like, I'm gonna say it. I heard 3.
Starting with your brother, where was he when the gunshot started going?
He was by the door, standing up by the door.
Which door?
The front door.
Where are you when the gunshot started?
I'm on the other side, like by the hallway type thing.
Okay. And when the gunshot started going off, what are you doing?
I was in the right, I was running in the back.
Okay. And then what happened?
Love court, that's when we got the shooting.
How many shots at this point?
I don't know how many times I got shot. I would say about 4.
Okay. Were you hit?
Yeah.
Where?
I got shot in my back, my hand, and took both of my thighs.
Both of your thighs?
Yeah, my legs.
Okay. What happens when you're hit?
And then I was on the floor. I was on the floor. They left out. I heard them skirt up. I looked up. They took my down. They had my phone, so I'm like, I had to find the closest phone to me. So I found my other phone. So I called the boys, like, I need an ambulance with them.
Okay,
So then,
so if you're saying a lot. So first you couldn't find your phone, correct?
right,
Okay, so you had to go find the next closest phone.
right.
Do you know whose phone that was?
Yeah, that was my other phone.
Okay, so you had two phones.
Yeah.
And then you said you called your boys to get an ambulance?
No, I called like the boys, the police.
Oh, the police, I misheard you, that's okay. So you called the police, asked for an ambulance?
Yeah.
What'd you do next?
Well, they pulled up. What I do, I crawl to the couch so they can see me. So I stand up to the window so they can see me. So when they found out what was going on, they came to the side door. And they came in.
How long did you stay in that house after the police got there?
I'm sorry, I stayed in there like for a good little minute. Till the ambulance came.
And who got there first, the police or the ambulance?
The police.
And once the ambulance arrives, where do you go?
They checked on my brother first, but they was like, no, I'm gone. So they put me on here and they took me out.
Okay. Do you recall which hospital you went to?
St. John.
Okay. How long were you at St. John's for?
Like for, so like I said, I had no more than like 1 or 2.
You said about a month or two?
Yeah.
So I'm gonna go back to the shooting itself really quick, Mr. Adams. From the time you hear risk say, shoot these, I'm not gonna say the word. How long between when that's said and the shooting itself?
You said it one time.
About how long passed? So seconds, minutes between the order to shoot and the shooting itself?
Like, like how you trying to say how, like, for what he said in the shooting?
Yeah, so when you hear risk say, pop these guys, shoot these guys.
How fast it went on?
And then how long after till the shooting?
As soon as he said it, well, that's when the bullet started flying.
Okay, so it's pretty quick, seconds, right?
Right.
Okay. And when Risk arrived, did you see how he got there?
Yeah, he got off the car.
Which car?
That 300, but I ain't know all this to feel me, so I know.
So I'm asking you what you saw, okay?
Okay,
That's all I'm
okay,
asking. Did you see him get out of the car?
No, I ain't seen him get off the car.
Did you see any other vehicles on Lappin Street besides that 300 you're talking about?
No, just that.
Okay, and when you are taken out of Lappin, after all this happens, is that car still there? If you know, only if you know.
No, the car was still there.
It wasn't?
No.
Okay. So other than the individuals you saw, Risk Lowesley's and your brother in the house, did you see anyone else at any point?
No, I ain't seen nobody else.
Okay. Did you see where Lowe and Sleaze came from?
Yeah, they came out the 300, the car.
Okay, so you saw him get out of the 300?
Yeah.
Okay. Thank you, Mr. Armstrong. I don't think I have any further questions.
Cross examine?
Mr. Adams, on the day of the shooting, have you been living at that house on Lappin?
Yeah, I've been living there.
Okay, and that means spending the night there?
Spending the night?
Yes.
Yeah, it was there.
Well, either you were or you weren't.
Yeah.
Okay, and who lived at the house with you?
Who lived in the house with me?
Yes.
I was living by myself.
Okay. And I believe you at one point referred to it as a trap house, maybe several points, correct?
All right.
Dope was being sold out of the house, correct?
All right.
And you were selling dope out of the house, correct?
No, I don't got nothing to do with that.
Okay, well, who has something to do with that?
I ain't got to find out. I don't got nothing to do with it.
I didn't understand what you said.
I don't got nothing to do with it.
That's not my question. Who was selling the dope out of the house?
I don't know the name.
Pardon me?
I was living there. I don't know the name.
Do you know the street name of the person selling the dope out of the house?
No, I was just living there. I ain't nowhere else to stay.
Okay, was your brother selling dope out of the
No,
house?
my brother's only there because of me.
Pardon me?
My brother's only there because of me.
Didn't you just testify a few minutes earlier, though, that your brother was selling dope out of the house?
Probably did.
Okay, did you observe him selling dope out of the house?
Probably did.
Did you observe him selling dope out of the
No,
house?
I ain't do it.
Pardon me?
No.
Now, you testified about Risk, Low, and Sleeves. Do you know Low's a real name?
Do I know his real name?
Yeah.
No, I don't know his real name.
And do you know Sleeves' real name?
No.
Do you recall testifying before Judge King before?
Yeah.
Okay. And at the point in time that you testified before Judge King before, did you know Risk's a real name?
Yeah.
You did?
Yeah.
Okay. Did you tell the prosecutor and the defense attorney, Mark Brown, that name when they asked you questions?
No, I take that back. No, hold on. Let me. No, I found his real name after all this court stuff.
Okay. Now, after all the court stuff with Judge King, Mr. Keel before, and Mr. Brown, did you have any conversations with the prosecutor about your testimony?
Nigga, I did. Alright, so.
I'm sorry.
Would you say what you said again?
Sure. You recall testifying before Judge King before, I believe it was maybe back in.
Yeah, I did. I just did.
Okay. After that testimony, did you have any meetings with the prosecutor to discuss your testimony in court today?
Yeah.
Okay. When was that meeting?
Yesterday.
Pardon me?
Yesterday.
Okay. And who was present at that meeting?
Robert then.
Pardon me?
I don't know what you asked me. Hold on. You asked me, my attorney who I was talking to yesterday?
Yes.
Bro, right there. I don't know his name.
Okay. This gentleman that I'm pointing to right here, Mr. Keel?
Yeah, I think it's him.
Okay. Was anyone else in the room?
No, I think it was him. I don't, bro. One of them.
Okay. One of these two gentlemen at the prosecutor's table? Okay. They do look a little alike. That is true. They could be mugshots in the same photo line.
You know, he used to have a little more hair on his face.
Right. And they discussed your testimony with you yesterday and how to testify in court, correct?
Right.
Okay.
Well, he didn't do that. He told me, I was talking to him, chopping it up with him, and we was talking like what. But he didn't tell me how to do what I was doing right now. Nah.
Well, what were y'all talking about?
We talking about what I was supposed to do with him.
Pardon me?
We was talking about how, we was talking about how, don't do how I was the first time I was in here.
Right, because you used some bad language the first time you were in there, right?
Right.
And in fact, at one point in time, the judge had to tell you to talk like you had some sense, correct?
Right.
Okay. Now, on the day of the shooting at the house, was there anyone else in the house besides you, your brother, Risk, Low, and Sleeves?
Nah.
There wasn't?
Nah.
How long had you been at the house before Risk came over?
Say again.
You were at the house in Lappin, correct? On the day of the shooting. You got there obviously before Risk got there, correct?
Yeah.
How long had you been at the house before Risk got there that day?
I was already there. I was really chill.
Okay. And when Risk came over, what was the purpose of him coming over?
You should ask him, I don't even know.
Okay. Did you two used to hustle together?
No, he used to try to be my pet, that's it.
Pardon me?
He used to try to be my pet, that's it.
Say that. He used to try to be your pet.
Peasant.
Okay.
Peasant.
Okay, inquiring minds want to know, what does that mean?
So he used to try to want to hang type thing.
Okay. You get money off you?
Get money off me. No, he just wanted to be like me, that's it, that's all.
Pardon me?
He just wanted to be like me.
You want to be like you?
Yeah.
And was that have an individual that was selling dope out of a trap house?
No, I never nothing to do with no dope. I never nothing to do with no dope.
After the shooting, you were taken to the hospital, correct?
Yeah.
And the police came to see you at the hospital, true?
True.
And you initially lied to the police, did you not?
I did do that.
Pardon me?
I did do that.
Okay. And the police came back and talked to you again, did they not?
Yeah.
Okay. And they asked you about where was the work in the house, correct?
Yeah.
Okay.
I don't know about that.
You don't know about that?
No, I don't.
Well, did the police ask you where the work was at the house?
No, I ain't even get no question like that asked you.
Okay. Did you ever tell the police that the people that robbed you took the work?
I never told them like that.
Okay. Did you ever tell the police that there was boy and girl in the house?
I never said it like that.
Did you ever make the reference there being boy or girl in the house?
I mean, they asked me, I said, I don't know what it is, but.
Okay, so you told them you don't know, you told the police you don't know what they mean when they ask you questions like that?
Yeah, I don't know what boy and girl is. I was on left to stay there. I ain't had nowhere to go. My dude put me out, man.
Okay, but did you tell the police you didn't know what they meant by both?
Right, I didn't tell them that when I was there with the judge. Right.
Do you know what boy or girl is?
Nah, to this day I still don't.
Okay. Now, when you were at the house that day before the shooting, were you using drugs?
I was not using drugs. No, I ain't got nothing to do with drugs.
Okay.
I don't know what they is.
You don't know what cocaine is?
No.
You don't know what marijuana is?
Well, I know marijuana is, yeah, for sure.
Okay, you don't know what heroin is?
Never heard of that.
Okay. You don't know what ecstasy, Molly, or anything like that is?
I don't know what that is, but.
Is there any of that in the house?
I don't know, sir.
Get one more, Judge. Judge Ross, thank you.
Can you redirect?
Well, Judge, I'm sorry. Can I ask, there was that area I forgot about.
You had indicated initially, Mr. Adams, you initially indicated when the prosecutor asked you that my client didn't say anything before the shooting, correct?
You said one more time?
Sure. Mr. Keough, the prosecutor, that's the prosecutor's name, asked you if my client said anything before the shooting, and you initially said no, correct?
No, I probably didn't read the words, but you know, we were saying to each other, what you mean?
What do you mean, read the words? Were you given a transcript of your last, your testimony at the last hearing?
Yeah.
Was you given that transcript yesterday?
Yeah.
Okay. And you read that before testifying today, correct?
Right.
Okay, so, and you would agree with me that when you first testified, you said that the risk didn't say anything before the shots popped off, correct?
Yeah.
Okay, and then Mr. Keough said, whoa, do you recall your prior testimony? And you said a few more times that he said nothing, correct?
I don't recall, but I guess, yeah.
Okay. And then after Mr. Kehoe talked to you about your prior testimony, that's when you said that that Risk said something like, shoot those guys, correct?
Right.
Okay. But the fact of the matter is, you don't recall what was said or what happened, correct?
Right.
That's all I have. Thank you, Judge.
You redirect.
A few things, Mr. Adams. First, we didn't meet yesterday, did we?
Nah.
You met with us, Sergeant Gunther, to my right, fair?
All right.
Who provided you this transcript you indicated you just had?
Sergeant Gunther.
He gave you a transcript?
Nah. What's the transcript? Hold on.
Was it a transcript or your prior statement? Okay, so have you ever seen the transcript of the prior court proceeding?
Yeah, I think that's what I got here.
So who gave you the transcript?
Sir, do you even know what a transcript is?
No, that's what I'm trying to figure out what it is.
All right, so when we're talking about a transcript, we're talking about the last time that you were here. See that lady that's over there that's doing that typing? She's typing down everything that's being said in the court. Has anybody provided you of your testimony from the last time that you were here?
No.
Okay, just so we're clear, you're talking about not a transcript, but your prior written statement.
Right.
Okay, that's what Officer Gunther went over. Is that fair?
Right.
Okay. In terms of your meeting with Officer Gunther, did he ever tell you what to say to that?
No, he didn't tell me nothing what I was gonna say to take off.
Just to stop goofing off like last time, right?
All right.
Okay. So in terms of what Mr. Gonick just asked you about what was said, do you recall what was said before the shooting?
No. Yeah, I remember what was in the first shooting.
Okay, because you've given a lot of confusing answers, so I want to make sure we're on the same page. What was said before the shots are fired?
Before the shots was fired, Risk said, shoot these ends.
Shoot these what?
You can say the word.
You can say the word.
He said, shoot these niggas.
Since you've been released from the hospital, have you been given any sort of medications that would affect your memory, sir?
No.
Are you on any medications right now?
No, I ain't on that.
And to be clear, you called it a trap house because you knew someone was selling out of that house, right?
All right, you can say it like that, yeah.
Well, I'm asking you, you called it a trap house, fair?
Right.
Okay, because you know someone's selling drugs out of that trap house, right?
Yeah.
You're being a little reluctant about talking about it, isn't that fair?
Yeah.
Okay. But testified as Mr. Gonick said, that it was your brother that was selling drugs out of that house, is that correct?
I know I testified about that then, but
That's, and
I didn't see that.
Mr. Adams, I appreciate that, but you gotta answer my question, okay?
All right.
You testified that it was your brother that was selling drugs out of that house.
No, I ain't testifying that.
You said that earlier today.
That's not true.
Well, who was selling drugs out of that house then?
I said, I don't know who was selling out of that, but my brother wasn't, because my brother was under there when I was there.
Okay, but you know someone was selling drugs out of that
All right,
house.
because I was just living there. Well, not living there, just staying there.
Thank you. Nothing further, Judge.
Mr. Adams, I want you to understand a few things about the law. One of which is that you told us that you were in a trap house. We all understand what a trap house is. A trap house is a drug house, right? All right. All right. I don't want you to think that by you telling us that you were selling drugs out of the trap house that you could get in trouble. Because we have a thing in the law called corpus delicti. That means that just by you saying that you sold drugs, you can't get in trouble for that. We would have to have the actual drugs that you sold as well, okay? So it's okay to tell us the truth because your brother was killed, right? Right. And you want justice, don't you? All right. All right, so it's important that you be absolutely 100% honest. I don't care how bad it makes you look or how bad it makes your brother look or anybody else look. We need to know the truth about everything. Understood? All right. Okay, can you tell me the truth? All right. All right, I'm telling the truth. All right, so who was selling drugs out of that house? It was my brother. Your brother was? All right. Okay. So you told us that he wasn't at first because you didn't want him to look bad, right? All right. All right. Okay. And did you sell drugs out of there too? No. Never? No. Never. Okay, you just had to have some place to stay. I think you testified to, is that right? How old are you, sir? I'm 18. How far did you go in school? I got 1 more year and I'm done. Okay. That's important. I want you to finish, okay? I got you. Any questions based on my questions? All right.
You indicated your brother sold dope out of that trap house?
All right, I did.
Okay. And the house wasn't your house, correct?
Right, it was.
Whose house was
I don't know who house was it.
Pardon me?
I don't know who house was it.
Okay, well, who did you ask if you could stay there?
Well, I asked.
Yes.
No, I was, it was just around.
Or the house was just around?
Yeah.
Okay, was it an abandoned house?
No, it wasn't no abandoned house.
Did someone live at the house?
Did someone living?
Yeah.
No, nobody living there.
Okay. So you just went in the house without asking anyone?
No, I didn't just do that. It was just, I was just walking up the block because I'd be over around 11.
Okay. You were walking up the block and you see a house and you decide, I'm gonna go spend the night at or live at that house for a bit?
No, I ain't said, no, it wasn't like that.
How was it? Like, what was it like? Or what caused you to live there? Sorry.
What caused me to live there? Somebody was outside. They was like, I was chopping it up with them for a minute. They was like, I was like, my dudes put me out and then they was like, you trying to stay here and jump? Ooh. I said, I just spend the night and then I ain't trying to live here.
I have nothing else, George.
All right. Anything else, Mr. Keon? I don't think so. No, thank you. Thank you, sir. You may step down. That's not. Any other witnesses for the people? Any witnesses for the people? No, sir. People?
All right, find over at charge for complaint form. Speaking just to the testimony from today, Judge, I know you've heard this exam now twice. It's clear from the testimony that the individual identified as risk first appears at the house on Lavin Street, where Mr. Adams and his brother were at, or at least one of the Adams brothers was selling dope out of the house, Judge. At some point, the other two individuals get out of the 300 that Mr. Adams testified himself outside, comes to the door, Mr. Adams lets in, and guns are produced. Mr. Adams is taken downstairs. There's a search of the house, he says, comes back upstairs, and at that point, Risk, identified as Mr. Banks here in court today, orders the shooting of both Mr. Adams and his brother. For that reason, Judge, and obviously, there's been no other testimony about anyone other than the individual identified as below having a firearm. But certainly under an aid or abettor theory, this is certainly words of encouragement and goes to the premeditation deliberation aspect of the shooting. The order for a kill shot, and then this is all done during the course of an alleged robbery of this trap house. I think by a probable cause standard, this has been shown that this crime was committed by the defendant in the city of Detroit, that we should be found over in court as charged with form. Thank you, Judge.
Yeah, just briefly, we would object to the bind over. We understand that the prosecution is proceeding under an aiding and abetting theory. As it relates to my client, there was no indication that he participated in any alleged robbery of the Latin house. The testimony from Mr. Adams was initially that my client said nothing before the shooting, and he maintained that in a few answers while being questioned by Mr. Kehoe. And then when Mr. Kehoe indicated, well, do you recall your prior testimony, prior transcript? Then he changed up and he said that my client said, shoot them ends, you've heard the word. And then when I cross-examined him, once again, he said he didn't recall what was said. And then I believe on reiterated again. I don't, I understand this is just an exam, but given the conflicting nature of his testimony and the incredible nature of his testimony as it related to a lot of unrelated things to the elements of the offense, I don't think a bind over is proper here, Your Honor, and I would ask the court dismiss the case.
Anything else, Mr. Kehoe?
Judge, you've heard both examined and the prior transcript, obviously not substantive evidence, but the fact that he testified consistently with that, I don't think that the inconsistency is really an issue, Judge. And the fact is, you've seen Mr. Adams, he certainly doesn't want to be here. He's very reluctant to talk about what's actually going on in that house, but for good reason, Judge. So I ask that you still find out.
Judge, I know I don't get another say, but I would just object to anything in the former transcript. I believe you, the court knows.
I'm not considering.
Okay, thank you.
What I will tell you though, is that as our jury instructions indicate, that you can believe all, part, or none of any witness's testimony. So clearly this was a witness who comes with his issues, in that he was less than forthright about the trap house in and of itself. Why? Because they're selling drugs out of it. He knows darn well what boy is, he knows what girl is. He knows who's selling boy, who's selling girl out of that house. He knows exactly what they're doing. He knows what he's doing. He's not just laying his head there because he has nowhere to stay. You don't stay in a trap house without being fully engaged in what's going on. Him and his brother. And he was less than forthright about coming forth and indicating what he was doing there, even what his brother was doing there, for whatever reason, maybe he doesn't want to make his brother look bad. And he wants to keep him in that light of being a victim. I get that. But I do believe him when he says that he saw this 300, I take it he means a Chrysler 300, parked outside. I do believe him when he says the defendant and others came in that house, took him to the basement and began searching through the house, looking to get the girl, boy, and or money. And I believe him when he says that the defendant said, shoot these ends. The defendant aided and abetted in the first degree murder premeditated of Tyrell Adams. Tyrese Adams, I'm sorry. Tyrese Adams, Jr. And in the assault with intent to murder Tyrell Adams. In the amount of aid or encouragement one gives another in the commission of the crime, that person can be charged if they are in fact innocent. this defendant, according to this witness, who has every reason to want to seek justice for the death of his brother and the shooting of himself, says what Lowe did, and says what this defendant did. Court does recognize that there was a point in time indicated that the defendant didn't say anything. But then he was reminded of his prior testimony. And then he said, when questioned again, not just about the prior testimony, but what took place on that date, what happened just before the shooting. He was able to give descriptive detail as to not only the shooting, but how much time lapsed between those words that were allegedly uttered by the defendant and then when the shots rang out. So the court is satisfied that the verdict of probable cause as it relates to count 1, homicide, murder, first degree premeditated juvenile defendant. Count 2, the felony murder. Well, I don't think it was flushed out as well as it was at the first exam. And of course, not considering the first exam, I'm confined to the corners of this exam. It does appear to this court that there was a robbery or attempted robbery that was going on in this location. And that as a result, Tyrese Adams was killed in the perpetration of that robbery, that armed robbery. So the court will bind over on count 2, as well as count 3, assault with intent to murder Tyrell Adams. Court finding those charges were committed in the city of Detroit. The court finding probable cause to believe this defendant committed will bind the defendant over to Wayne County Third Circuit Court Criminal Division for proceedings. His arraignment on the information date and time will be August 8th, 2024 at 9:00 a.m. And it will be remanded to the custody of Wayne County Sheriff. Thank you. Okay. Thanks, you too, Mr. Kenneth. Take care now.
All the way to the bottom.
Good morning, John.
Hey, Mr. Johnson, how you doing?
Holding on, man. How you doing?
Huh?
I said I'm holding on. How are you?
I'm doing very well, thanks. Are we just about ready on Bush?
Ready or not?
Here we come.
I had my second cataract surgery 2 days ago.
How'd it go?
I wasn't about to call you for adjournment.
I appreciate that, man.
You know what I'm saying?
I appreciate
I
that.
said,
How you doing?
I can hear you.
Successful?
To hear you telling me already know your answers, you know, your various ones depending on the facts. Which is a good thing.
There's no wheelchair, Judge. Oh, okay.
They come through the front.
Mr. Johnson.
Good morning, Judge.
Good morning, how you doing? Thank you so much for your assistance.
You're welcome, Judge.
You're welcome. Okay. Carintha James Bush, calling case 2457756. People of the state of Michigan versus Carintha James Bush. Defendant is charged in count 1 homicide, murder, second degree. Count 2 weapons, firearms, possession by a prohibited person. Count 3 and 4 felony firearm. Defendant has a habitual offender, fourth offense notice, mandatory 25-year sentence. Appearances for the record.
Good morning, Your Honor. John Bell on behalf of the people, P68673.
Good morning, Your Honor. May it please the court, Berkeley Johnson, appearing on behalf of Kenneth Bush, P46646.
Your name for the record.
Corinthian James Bush.
There's date time set for preliminary examination. Are we ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
How many witnesses will there be?
Can you call 2 witnesses?
Any preliminary matters before you start your witness?
Your Honor, if I may approach, there's a stipulation to the only exhibit I'm going to use, People's Exhibit number 1, which is the postmortem report taken as case Christopher Watson. May I approach?
Yes, so stipulate for purposes of preliminary exam.
The court receives that stipulation and will admit the exhibit. Thank you, sir.
Your Honor, we have one more just minor stipulation. It's for preliminary exam purposes only. That is relative to count 2. The defendant had been previously convicted of carrying a concealed weapon, specified felony. He has not regained eligibility to possess a firearm, and that stipulation is for exam purposes only.
So stipulated.
So stipulate for
Purposes of stipulation. If I hadn't said it already, folks out there in YouTube land, if you're a witness or potential witness, I'm going to be logged off this time. Do we have an exception for OIC to remain?
I would ask the OIC to be allowed to remain. She's seated next to me in the court.
No objection. Okay. All right.
Thank you, Your Honor. Can you call to the stand Danielle Logan?
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please have a seat. The witness box next to me. Voice up microphone, speak to that microphone with the white on it. Yeah. And begin when you're ready.
Thank you. Good morning, Ms. Logan. Can I ask that you state your full name and spell it for the record, please?
Danielle, Donielle, Logan, Logan.
Thank you, Ms. Logan. Ms. Logan, I want to get right to the point. Do you know an individual by the name of Carintha James Bush?
Yes,
And how do you know Carintha James Bush?
he's my uncle.
Your uncle? The person you know is Carintha James Bush. Do you see him in the courtroom today?
Yes,
Can you point to him, identify what he's wearing?
a green outfit in the back.
Thank you. Your Honor, may the record reflect the witnesses identifying the defendant, Carintha James Bush.
So noted.
Ms. Logan, I'm going to direct your attention to June 10th of 2024. Were you outside the location of 11676 Marlowe in the city of Detroit, the state of Michigan?
I was outside sometime during the day.
Okay. And what time during the day were you outside that location on June 11th? I'm sorry, June 10th of this year?
I was outside when the incident happened.
Okay.
Well, the first incident happened.
Okay. And I'm going to ask you about that. Let me just clarify. Was it daylight during the day?
Yes.
Okay. And at what is located at 1167 Marlowe?
That's where I reside. I live there.
Your home?
Yes.
And who do you live with?
I live with my uncle, my mom, and two of my aunts.
And who's your mother?
Guinevere,
And who are your aunts?
Rhea, Renita, and Renee.
Thank you. Now, you mentioned the first incident. Let me just ask you this. Do you know an individual, or did you know an individual by the name of Christopher Watson?
Yes.
And was Christopher Watson present outside of your home on June 10th, 2024?
Yes.
When you refer to the first incident, was Mr. Watson involved in that first incident?
Yes.
Was the defendant also involved in that first incident?
Yes.
And can you explain to the court what type of contact Mr. Watson and the defendant had on June 10th?
It was no physical contact. My uncle Chris actually came to the house to see me. And as Chris was coming up, my uncle just said, you know, you need to slow down, you drive too fast. And that's all he said. And Chris immediately just started yelling, you know, nigga, what? Mind your business, mind your business, mind your business, nigga, what, nigga, what?
And Miss Logan, unfortunately, I can't ask you what Mr. Watson is saying, but let me ask you this. Did they exchange some words between Mr. Watson and the defendant?
No, my uncle said what he said, and then Chris just went off.
Okay.
I didn't hear my uncle say anything after that.
Okay. Why was Mr. Watson at your home on that day?
He owed me $10.
And did you know he was coming over on that day?
Yes.
And did he come over to give you the $10 he owed you?
Yes.
Now, after there were words exchanged, did Mr. Watson leave the location?
Yes.
Was he driving a vehicle?
No.
So he left on foot?
Yes.
Now, a short time later, did you see Mr. Watson return to the area?
Yes.
During this time, where was the defendant?
He was in his vehicle.
And what type of vehicle was that?
A white Expedition.
And he was just sitting in his vehicle?
Yes.
Just to be clear, what seat was he sitting in?
The driver's seat facing towards Plymouth.
Okay. So he's sitting in the driver's seat of his Ford Expedition?
Yes.
How long was he in his vehicle for?
I don't know, from the first incident, he was still sitting there until when Chris came back.
Okay. Do you know approximately how long that was?
No, maybe 5-10 minutes, I don't know.
And when Mr. Watson came back, did he specifically go to the defendant's vehicle?
Yes, I was in the house, but my auntie said he pulled up.
Okay. And again, I can't ask you what somebody said, so that would be hearsay. But I understand you're just trying to answer my questions. Did you see him go to the defendant's vehicle?
Yes.
And what did, and I can't ask you what Mr. Watson said, what did Mr. Watson do when he arrived at the defendant's vehicle?
He was standing on the side of his door, driver's door, holding his pants.
Okay. And when you say driver's side door of the defendant's vehicle?
Yes.
Do you know if they were exchanging words?
I couldn't hear my uncle saying anything, but I heard Chris.
You say he was holding his pants. Can you stand up and show me how he was holding his pants?
He was holding his pants like this, and he was yelling at my uncle.
Turn around so I can see.
He was holding his pants, yelling at my uncle.
Okay, indicating for the record, she has both of her hands on the waistband of her, front of her pants and moving up and down.
Thank you, Your Honor. Ms. Logan, did you ever see Mr. Watson with a gun or any type of weapon that day?
I couldn't see, his back was to me.
Okay. So is it fair to say you never saw him with a weapon?
No, I did not see a weapon.
Okay. And did you ever see the defendant with a weapon that day?
No.
Okay. What happened as Mr. Watson was outside the defendant's vehicle?
He was holding his pants and he was yelling at my uncle.
And I can't ask you what he was saying, but okay.
Yeah, he was just yelling at my uncle. And, next thing I know, he was falling.
Did you hear any gunshots?
I didn't hear anything. I just heard Chris yelling. He was yelling.
So he's yelling and then you saw Chris falling, Mr. Watson falling?
Yes.
Okay. After Mr. Watson fell, what did the defendant do?
I don't even know because I focused on Chris.
Did you go out to Chris?
Yes.
And did the defendant drive off?
I don't know. I don't remember what he did because I was focusing on him. My aunt was yelling and I was focusing on him.
Okay. And when you saw Chris fall, he was standing next to the defendant's vehicle?
Yes.
Which side of the vehicle?
The driver's side.
Okay. And when he fell, you went out to help him?
Yes.
Why did you go out to help him?
Because he fell.
When you say he fell, was it like a trip and fall or did his body?
No, he just kind of like laid back, you know, just, it was a slow motion. He just fell. That's all I know. He just slowly fell down. Wasn't like he fell hard or anything. He just fell down. I was actually on the porch, so I had to get down there too.
Okay. And when you got down to Chris or Mr. Watson, did you notice any injuries on him?
I just saw his shirt was you know, you can see a little blood on his shirt.
Where at on his shirt?
Right here.
You're pointing to the left above your chest, between your chest and your shoulder blade?
Yeah, it looked like it was bleeding from his, you know, his shoulder like area.
Okay. Was he responsive at that time?
Yes, he was, yes. My auntie was actually talking to him. And yes.
And did you, did you try to assist Mr. Watson or help him?
My auntie was down there, I was calling 911.
And did the paramedics and police arrive?
Yes.
And did they take Mr. Watson to the hospital?
Yes.
And you were interviewed by the police, is that correct?
Yes.
Do you recall being interviewed by the police on that day regarding this incident?
Yes.
Do you recall telling the police that there was a gunshot was fired by your uncle?
No. I know a gun was shot. Chris was on the ground, shot. I didn't see him shoot him. I didn't hear him. I didn't hear a gunshot. I just saw Chris fall.
Okay.
All I could hear is Chris yelling. And like I said, he was yelling and then he fell. I didn't see nobody with a gun. I didn't see a gun. Chris back was to me, so couldn't even see my uncle because he was standing in the view of my uncle.
Okay. Was anybody else around that area at the time that Chris fell?
My auntie.
Okay. But no, around the area of your uncle's vehicle, there was no other people around other than Chris? Is that a yes?
No, no one was around.
No one was around. Okay. Thank you. Thank you, Ms. Logan. I don't have any further questions for you at this time. I believe the defense counsel will.
Cross-examine.
Good morning, Ms. Logan. I know this has been a stressful situation for you, and I know you had to talk to several police officers that day, correct?
Yes.
And it appeared to you that the police, though you had given a story to one officer, it appeared to you that all these officers wanted you to reiterate what you had told the first officer, correct?
Yes.
So you may have left a fact out or or something may have came to you, but you talked to the police and you were trying to be honest and forthright with the police at that time, correct?
Yes,
Okay. And then homicide came late, right? And that's when they asked you to give us the statement to the officer that evening, correct?
yes.
So that's the statement I'm gonna really focus on. So I'm gonna ask you some questions, and if you have a hard time recalling based on what you said, just say that. And if you don't understand the question, just tell me and I'll repeat it and try to make it more clear to you.
Yes.
You knew the victim prior to this incident, correct?
Yes,
And you didn't know of any bad blood between your brother, Mr. Bush, and the victim, Mr. Watson, right?
that's my uncle, no.
Yeah, I'm sorry. In fact, as you said, Mr. Watson came down to your house to see and talk to you on that day, correct?
Yes,
And you all were talking in the walkway leading up to the house just prior to the first incident, right?
yes,
And your brother who resides with you pulled up home to drop off a soda pop to you, correct?
he had already dropped the pop off.
Okay.
He was sitting there still.
But that's how he happened to be there.
Yes,
Yes, okay. And those are the kind of little intricate differences might be in my questions, so you can straighten those out. Feel free to. In fact, your brother pulled up and he parked on the opposite side of the street, correct?
yes,
Going in the opposite direction, correct?
yes,
So that means, just so the court will understand, if I'm headed this way, the street's a two-way street. Your house is on this side, right side where he's parked, right?
yes,
He was parked facing the wrong way, correct?
correct,
Which made his driver's door on the side of the house,
correct,
right?
yes,
And it made his passenger door towards the middle of the street, correct?
yes,
Okay. And your brother suffers from some serious medical conditions, correct? In fact, your brother,
he's my uncle.
I'm sorry, I've been preparing this stuff and I've been doing it myself, I'm sorry. Your uncle, Mr. Bush, suffers from some extreme medical conditions, correct?
Yes,
And on this day in question, one of the conditions is, he has a very large swollen scrotum, correct?
yes,
Almost the size of a cantaloupe.
yes,
Okay. And so he has to walk. If he walks, he has to actually carry his scrotum and he can only move very slowly, correct?
Judge, I'm gonna object as to the relevance to this question.
Judge, I'm gonna tie the relevance.
Too much information.
Yeah, I knew it was gonna engender that, but it's very important because it goes to our defense and his ability to act and react or run or, you know.
I'll give you a little.
Yeah, that's all I want, Judge. I just want the court to understand that because it's relevant. So when Mr. Bush parked on that side of the street, it helps him to get out of the car and go into the house much more easily, correct?
yes,
Okay. And you've known sometime that he might have high or low blood pressure based on his cirrhosis, and that he can become dizzy or fall out and things of that sort, correct?
yes,
And you all care for him and help him in those times, correct?
yes,
Okay. And in fact, I'm just speeding ahead so we can get through this. When he left the scene after the shooting, no one knew where he went immediately, correct?
No,
And police were asking you, where could he be, were the relatives and things of that sort, and you all told them no, right?
yes,
And at some point, Miss Renita, your aunt, right?
yes,
She was trying to contact him by phone and he kept going to voicemail, correct?
yes,
And then at some point, he contacted someone and told them he was at the hospital, correct?
I don't know.
I'm gonna object this to your
But you learned later that he had driven himself to the hospital, correct?
Yes.
Okay, again, I'm gonna object this lack of foundation.
Judge,
Or her knowledge of that. other than-
Just,
I have to sustain that objection.
okay. At some point, the police informed you that he was at the hospital and they went to see him there and interviewed him, correct?
Judge, again, I have to object this.
I'll move on. So as your brother got out of his car, recall him getting out of his car when he originally came into the house? I mean, your uncle?
Yes, he came in, he brought my auntie a pop.
You didn't hear what he said to Mr. Watson, did you?
Yes, he told Chris, that he should stop driving up and down the street fast.
Okay, so that, you're characterizing the best of your memory on what he might have said.
Yes,
But it has something to do with him flying up and down the street every day, right?
yes,
And he said that he almost hit it.
yes, he did.
I'm gonna object this to your
Well, by a party at home.
Well,
Sustain.
pardon, Judge?
Sustain.
Yeah. At that point, when he made those statements, Mr. Watson went ballistic, right?
Oh, yeah.
Okay. And when I say ballistic, he lost control, started yelling obscenities, cursing, as you indicated, using fighting words and things of that sort, correct?
Judge, I have to object this.
Judge, I'm laying a foundation
Conclusion
because
based on hearsay.
I'm laying a foundation because there's gonna be a lot of excited utterances coming in. So I'm laying the foundation for that.
Lay a foundation.
Yes. So when he started hollering, that raised the temperature right then at that point, correct?
Yes,
He was excited, your brother was there, you were there, you started trying to calm him down, correct?
yes,
You agreed that at that time, there was an atmosphere of excitement.
yes,
Yes, and that's when Chris or Mr. Watson started yelling all these obscenities, correct? These utterances came out of his mouth during that excitement, correct?
yes,
And he started using fighting words, correct? Obscenities.
I'm gonna object because for hearsay.
Judge, that is not hearsay. Those are not the words spoken, and they can come in. If I ask those words, they can come in as excited utterances.
Yeah, lay a foundation for it.
That's what I was trying to lay down, foundation, that they happened at or near the time of the excitement. She
So you
indicated,
have to ask her questions about her familiarity with the plaintiff witness. Have you seen, or how would you describe?
I was gonna do that.
She kind of put the cart before the horse.
Have you never seen Mr. Watson act that way, correct? You told the police that, didn't you?
Yes.
You told the police that you've known him for some time, but you've never seen him lose control like that.
No.
And you tried to calm him down,
Yes.
but you couldn't calm him down.
How would you describe his demeanor?
He was irate. It seems like,
What makes you say he was irate?
I never seen him yell like that. Yell, scream, his mouth was tripping. It looks like he was just at his boiling point, you know, and it took me by surprise because I had never saw him like that.
Did it appear he snapped in a kind of a way?
Yes, it's like he changed in front of my face, like changed into this monster. I mean, I had never saw him like that, and he just, you know, it was frightening.
And your Renita, she came out, right? Your aunt.
Yes.
Because she heard him screaming and howling, correct?
Yes.
And she tried to assist you in calming him down.
Yes.
And it just got more excited and at that moment, and he became even more irate, correct?
Yes.
Now, you tried to calm him down and direct and tell him to direct this conversation to you.
Yes.
And not your brother or anyone else, correct?
Yes.
At the same time, Renita was trying to do the same thing and get him to move away from in front of the house towards going back towards his house, correct?
Yes.
All during this time, this excitement and stressful situation was taking place, correct?
Yes.
And at some point, you even felt as though you all might be in danger or he might strike out at you, correct?
Yes, and we stepped back at that point.
And you and Renita discussed that even after he left, how that created some fear in you, correct?
Yes, my auntie said this is not over.
Judge, I have to object this.
That would be hearsay, sustain.
Well, if she said it, okay, but Judge, I suggest if she said it at the time of the incident during the excitement,
But
she just uttered it.
Went from the complaining witness being excited and what he said has a later foundation for her being excited as to what she said. So it's an out of court statement.
Okay.
For the truth of the matter asserted.
No problem. Did you honestly believe that you, your brother, or your uncle or Renita?
Uncle. I made this just for you.
Hey Judge, I've been doing this all, hey, as I prepared my cross-examen last night and this morning, I kept having to remind myself, I'm sorry. I'm gonna just say Mr. Bush. Okay. So, let's see, where was I? Did you honestly believe at that moment, ma'am, that you, Renita, or your brother may be in danger? I'm just talking about your honest belief.
I was scared.
Okay, just good. Would you say his shouting and the words he was using, he used them in an aggressive manner?
Yes.
Were they offensive?
Yes.
In fact, you couldn't remember all the words he used when you talked to the police, correct?
No, everything was just going so fast. It was just, it was crazy. y'all.
But he appeared to be in a rage, correct?
Oh, yes.
In fact, okay. And this all arose out of the one statement that your brother made to him,
Yeah.
your uncle made to him.
Yes.
Okay. I'm breaking the record. I'm marking my pins now. I'm breaking the record. I'm breaking the record here, Judge. During that time, you never heard your brother, your uncle, respond. I wrote that written down. You never heard Mr. Bush respond to Mr. Watson with one word.
No.
You never saw him retaliate or anything of that sort.
No. I was focused on Chris.
You saw Mr. Bush remove himself from that situation and go either in the house or to his car.
He got in his car.
Okay. You all continued to try to calm him down and walk him down the street towards his house.
Yes.
As Mr. Bush was going to his car, you admonished him, right? Addressing him about what he had said to Mr. Watson, right? You kind of.
I told him he should mind his own business. Stop saying stuff to people. You can't say stuff to people all the time.
Mr. Bush didn't argue with you. He just took it.
He got in his car.
So you eventually went in the house, kind of thinking that you would put the fire out a little bit, right?
Yes.
At that time, when the police questioned you about a firearm, you told them that you didn't know Mr. Bush to carry a gun, right?
Yes.
And you had an opportunity to observe Mr. Bush on that day at that time, right?
Yes.
And he didn't appear to be carrying a gun on his person when he left out the house to get in his car, right?
No, because he always told me this, you know.
Yeah, as I described earlier.
Yes.
So you didn't see him when he drove back up. That's what you learned earlier, but you saw him at some point, right?
I just saw the car when it pulled up.
Okay, all right. So when you saw the car pull up, you saw it stop in the middle of the street, right?
Yes, on the side of my uncle's truck.
On the side of your uncle's truck.
Yes.
Right? And you knew that was strange, correct?
Yes.
And you saw him jump out the vehicle and he left his car door open, correct?
I didn't see him jump out the vehicle. I saw him when he was in front of the vehicle.
Okay, so at the point that you came to the door, you were standing in the doorway or on the porch, correct?
I was standing in the doorway, and by the time I was standing in the doorway, Chris was standing in front of, he was coming around, my uncle's truck.
Okay, and again, it appeared to you that he was still out of control and had not cooled off, right?
Yes, he was yelling.
And he was yelling the same kind of words and things of that sort.
Yes, yes.
In a threatening gesture and making threatening gestures.
Yes.
Okay, and those threatening gestures were, as you characterized to the court, the pulling of the pants.
He was
or
holding his pants and nigga, now what? Now what?
in the waist area.
Yes.
Okay. And you didn't know what he was doing at that time, correct?
No, I just knew. I knew he was there, but he was very aggressive talking to my uncle. But I thought he was getting ready to jump off.
Okay. So at that point, you had an honest belief that that Mr. Bush safety may be in jeopardy, right?
Yes, I thought he was in danger, yes.
And before he returned and left, it was clear to you Mr. Watson had went away angry.
Yes.
You had tried to reason with him, but he kept yelling and being out of control, and that's the way he left. Now, you also knew that Mr. Watson had a habit of driving, speeding up and down the street.
Yes.
And at the time that you saw him verbally attacking your uncle at his car window, is that correct?
Yeah.
He did that in an aggressive way.
Yes.
And you knew from Mr. Bush's health and medical condition that he couldn't fight or defend himself, correct?
Absolutely not.
He could not run, get out the car and run for his safety, correct?
No.
He did not say one word or make any aggressive gestures towards Mr. Watson that you observed.
No.
He did not respond to Mr. Watson's actions in any way that you observed.
No.
When Mr. Watson returned with his vehicle in the manner that he did, Did he surprise you?
Yes,
And at that moment, your brother was peaceably sitting in his vehicle.
yes,
And this was all happening quick in a matter of seconds, correct?
yes.
You couldn't see Mr. Watson's face because his back was to you, correct?
Yes,
And you couldn't see Mr. Bush's face because Mr. Watson was blocking,
my view from my uncle.
and your uncle's window was down.
Yes,
And at that point, you couldn't see if Mr. Bush shot him or how he shot him or anything of that sort.
no.
But did you say you heard the gunshot?
I don't recall hearing it.
Okay, I just wanted to make
Chris.
sure, yeah. But what you did see, you kind of put everything together, right? In other words, you saw him run around to your brother's, to your uncle's car door, right?
Yes,
And at the same time, you saw the yelling, you heard the yelling and all that. And then you saw him fall.
yes,
And in your mind, you had an honest and reasonable belief that Mr. Bush may have shot him or something.
yes,
Okay. And that was based on your whole honest belief of what you had observed from all the facts, correct?
yes.
You never told homicide he was known to carry a firearm, correct? You,
Who was known to carry a firearm?
Mr. Bush.
Oh, no.
Nothing further, thank you.
Any redirect?
Just briefly. Ms. Logan, I just want to clarify, because we went through the different kind of incidents that you described it. The first time in this argument between the victim and the defendant, you never saw Mr. Watson with a gun or any weapon, correct?
No,
And the second time when he came back, you never saw him with a gun or any weapon, correct?
no, I just saw him holding his hands.
Okay, and when you were helping Mr. Watson after he was laying in the street bleeding, you never saw any guns or weapons nearby, correct?
No,
Okay. Now, defense counsel asked you questions specifically about knowing whether the defendant carried a gun. Did you ever look in his SUV to see if he had any guns?
in my uncle's truck?
Yes.
No, he wasn't there.
Prior to the shoot,
Oh, no,
you never looked in his vehicle or looked for guns, correct?
no.
At the location of 1167 Marlowe Street in Detroit, who in that home owned guns?
I do.
Okay, what kind of guns did you own?
I have a 380.
I'm gonna object to the relevance, Judge, lack of accommodation.
foundation, I'm asking her, the relevance is there were multiple guns and different ammunition taken from the home, so I'm just trying to clarify. And you had it was a Versa 380, correct?
Pardon me?
A Versa 380 handgun?
Yes,
Did you own any other guns?
no,
Okay. Are you aware of anybody else in the home owning guns other than your handgun?
no,
And was the defendant living with you at that time on June 10th?
yes,
And which bedroom was his?
the upstairs bedroom.
Judge, I'm object to the relevance and it goes beyond the scope of direct and cross.
He asked specifically about whether the defendant was known to have a gun.
And that was based on, okay.
And Miss Logan, I'm sorry, which bedroom was the defendant's?
Upstairs bedroom.
How many bedrooms are there upstairs?
It's 2.5.
Upstairs?
Yes,
And if you can describe which bedroom was the defendant's?
to the right.
So if you go up the stairs to the right,
Yes,
which direction, do you know, cardinal direction that would be?
to the, I don't know, to the right. You go upstairs, when you walk up the stairs, it's a room straight ahead, and then it's one to the right.
Whose
And then
room?
it's a half a room, a little over.
Whose room is straight ahead?
My mom's.
Is your mom own any guns?
No, not that I know. I just know what I own.
Thank you. I don't have any further questions.
All right, thank you, ma'am. You may step. Any other witnesses from you?
Your Honor, I'm gonna call, Renita Bush.
Good afternoon, ma'am. Please step forward, give your name and the spelling of your name to the young lady seated here. Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you. Please have a seat in the witness box right next to me. Voice up nice and loud and speak into that microphone to be to your left once you have a seat. One with the white one. Ready to get when you're ready.
Thank you, Your Honor. Good afternoon, Ms. Bush. Can I ask that you state your full name and spell it for the record?
Renita Bush, RHEANITA.
Thank you, Ms. Bush. Ms. Bush, I understand you don't want to be here, but I have to ask you some questions relative to June 10th of 2024. Where were you living on June 10th, 2024?
11-696 Street, Detroit, Michigan, 4226.
Thank you. Do you know an individual by the name of Corintha James Bush?
Yes.
What's your relationship to Mr. Bush?
Sister.
You're his sister. Unfortunately, I do have to ask you, Ms. Bush, can you just point to the individual, if you see him in the courtroom, that you know as Corintha Bush, your brother?
Point to him.
Point to him and identify him. Thank you. Your Honor, may the record reflect the witnesses identifying the defendant, Corintha James Bush.
So noted.
Ms. Bush, I'm going to get right to the details here. On June 10th, 2024, was there a shooting outside your home?
Yes,
Did you witness the shooting?
yes,
And did you see the defendant shoot a gun? And was he in his vehicle parked outside your home when he shot his gun?
yes,
Did you see the individual that he shot?
yes.
Was that person Christopher Watson? Okay. Now, Ms. Bush, as it pertains to Mr. Watson, after he was shot, did you try and help him? Or Chris, as you know,
Yes,
did you ever see any guns or weapons on Chris's person or around Chris? After your brother shot Chris, did your brother drive off?
yes.
Thank you, Ms. Bush. That's all the questions I have.
Cross
I believe the defense counsel has questions.
Good morning, Ms. Bush. Good afternoon. You didn't know of any bad blood between your brother, Mr. Bush, and Mr. Watson, correct?
No,
And you didn't have a relationship yourself with Mr. Watson, correct? Other than seeing him up and down the street as a neighbor. And you also knew Mr. Watson to speed up and down the street habitually, correct?
in person, I never seen.
Okay. Now, I want to address your first answer to the prosecutor's question of whether you saw the shooting. You gave a number of statements to the police at the time they were investigating after the shooting, correct?
Yes,
And, you know, you had police officers asking you to restate the facts on several occasions, correct? Then also you end up talking the homicide, correct?
yes,
But one thing was consistent. You told the police that you never saw him actually shoot Mr. Watson, correct? You heard the gunshot.
I seen Chris pull up on the side of my brother. And he was pulling on his door that made me go on front porch. And I'm just standing there and couldn't get the passenger to open, so he goes around and was driving on the driver's side. And he was just saying like, "Really, what, really what?" And I'm standing there and I just saw a flash.
Now,
And then-
Miss Bush, at no point in time did you tell any police officer in any of your statements that you saw a flash, correct? Now, we can go through it all and I can even put the tape on, so I'm asking you to try to give your best answer. You never
I saw
told,
a
wait a minute, we
flash or a
both
spark.
can't talk at the
Okay.
same time. You never told the police, not one, that you saw a flash. Am I correct?
What did I say, a spark? I thought,
No, you didn't say a flash or a spark. You said you didn't. I'm sorry. You said you didn't see the shots, and I can show you your statement if you want to see it. You didn't. Wait a minute, we can't talk at the same time. And I'm not trying to argue with you. I'm just trying to clarify and refresh your memory if I can help you. Just want you to take your time and answer the question truthfully. You never told the police, and this is specific, that you saw a flash, correct? You told them you heard a shot and saw him fall. Is that correct?
No, it's not.
Here we approach. Based on our side project. So at some point you saw your niece, Danielle, outside, you heard her outside trying to cool off Mr. Watson, correct? At some point.
Yes.
And you heard Mr. Watson hollering, cursing, verbally threatening your brother prior to the shooting, correct?
I mean, is it all right?
That's what
Ma'am, all I'm asking you.
That's what we want you to tell us, what you heard.
Okay. So I saw my niece talking to Chris and trying to calm him down, and that's what made me go outside. When I get outside, I'm like, what is going on? And I heard my brother say, man, all I was trying to tell you, you need to slow down because you be speeding down the street and you almost ran into me. And he was like, nigga what, fuck you, nigga what? And that's the same thing I said to T. He said this lady T about 4 or 5 times. So I walked up to him and said, Chris, I said, what's going on? Talk to me. And I hear him by his right here, and I said, calm down, Chris, calm down.
Okay, at that point, ma'am, I want don't want you to keep narrating, but I'm gonna ask you some questions from that point. You both were trying to get him to calm down and he didn't calm down. Is that correct?
No.
And you all tried to get him to leave and walk away and go towards his house. Is that correct?
No, he was already walking towards his house.
Okay, so at some point he walked towards his house, correct? And you and your niece had some discussions, and based on his conduct and aggressiveness, he even placed you all in some fear at that moment, correct?
So when I held his right hand, I said, Chris, please calm down, talk to me, calm down. And he like pulled his hand away from me and he said, calm down. His face was turned into a beast and he was like, calm down.
Did it place you in fear, ma'am?
It tells me to back away because he was angry and you could see it in his face. He was upset. He was very angry.
My question is, did he place you in any fear at that time for you and your niece?
Was I in fear? No.
Didn't you tell the police that you at some point felt like he might strike out at you and your niece? And you had that conversation with your niece? Yes or no, ma'am?
Could you repeat that?
Didn't you have a discussion with your niece that based on his aggressiveness, his yelling and his conduct, that at some moment during that time, he put you in fear that he might strike out at you or your niece, and that you didn't think this was going to end well? Yes or no?
Yes.
You never saw your brother not once respond to Mr. Watson's aggressive behavior.
No, I just heard him say that one thing. He needed to slow down.
He never engaged Mr. Watson at any other time, correct?
No.
In fact, he removed himself from the area and went to the house, or finally came out and got in his car, right? Where he sat, your brother. Your brother went in the house and came out and got in his car as if he was getting ready to leave at some point, right?
No, I don't recall it.
Well, you recall, you told the police you.
Okay. He was, I have always seen him sitting here.
Okay, you told the police that you saw him go get in his car, he had his keys in his hands at some point.
Okay.
And he was getting ready, as though he was getting ready to leave, correct?
Okay.
And the last time you saw your brother, he was sitting in his car, correct?
Yes, he was.
Peaceably sitting in his car, right?
Say yes.
And as you were in your doorway or on your porch, you made some observations, correct?
I was in a house.
Just let me go through these questions, ma'am, okay? So what you observed was you saw Watson drive up in his vehicle, right?
Yes, I seen him pull up on the side.
And he stopped in the middle of the street, right?
Yes, and he stopped on the side of my brother's.
And right next to your Mr. Bush's vehicle, right?
Yes, he did.
And you know Mr. Bush was parked on the opposite side of the street in the opposite direction, correct? And you also know that he has a very serious and extreme physical condition, right?
Yes.
And without going further, I've made the court aware of that. You know, you knew that by parking like that, it makes it easier for him to get out of the car and make his way up to the house, correct?
Yes.
But you knew there was a problem when you saw Mr. Watson reappear in 5 or 6 minutes from the time he left. You knew there was a problem by the way he pulled up next to your brother's car and jumped out trying to open up the passenger door, right?
Yes.
And you saw him pull to try to get in on the passenger door, correct?
Yes.
And the door appeared to be locked, right?
Yes.
He couldn't get in. And then you saw him aggressively come around the vehicle to the driver's side, correct? And you heard him aggressively yell and confront your brother at the driver's side of the vehicle where he was seated, right?
Yes.
You told the police he rushed around the car so fast your brother could not pull off because of the way Watson pulled up on him, right? You recall that? If you don't, that's okay. I don't expect you to remember everything you told the police that day. You heard Mr. Watson yelling and cursing, using fighting words at Mr. Bush at his window, right?
Yes.
As he tried to appear to.
So, Mr. Johnson, we can't read the report into the record. We have to get testimony.
No, but these are my questions. I'm not reading from the report, Judge.
Sounds like you read.
No, well, I'm not. These are my words, my questions. I'm just reading to make sure I get it correct. Okay, at any point, it was during this encounter that you heard the yelling, the cursing, the attacking of verbally attacking of Mr. Bush, that you heard a gunshot, or you heard the gunshot, correct?
First of all.
Miss, could you answer the question?
No, I did not hear no gunshot.
Okay. And as you were talking to the police in homicide, you indicated he ran up to Mr. Bush, right? And while he was aggressively yelling, he was pulling and making motions around his waist, correct? Can you stand up and show the judge what you showed the police when you indicated he was?
First of all, did you say that he was doing something around his waist?
You made.
Yeah, well, when he's in around the truck, he was holding his pants up, you know, with his right hand, he was holding his pants up.
Did you not motion to the police? Look at me, ma'am, please. Did you not show the police when you explained to them what he was doing? You did this movement around your waist?
Around my one?
Yeah.
No, I don't recall.
Okay.
I don't.
Do you recall indicating he made any motions around his waist area?
All I know, he was holding up his pen on his right side. He was holding up his pen.
Did Mr. Watson's actions towards your brother make you fearful for his safety?
Yes,
Why?
because the way he was acting and the way he was trying to get to my brother. And I'm standing there and I'm looking and I just could not move. And I saw a spark or a flash. And then I saw Chris going down and I'm like, did that boy just shoot him? And that's when I went down there to try to help Chris off and my brother pulled off.
So at that time, during that time, you felt fear for your brother's safety?
Yes.
And was your fear based on your honest belief at that time, based on all the circumstances that you had observed?
Yes.
You knew that your brother couldn't run, right? You knew your brother couldn't escape from that car, right? Based on his physical and medical condition.
Yes.
Did you honestly believe he could have been hurt, injured, or maybe even killed?
Judge, I have to object as to the relevance of this question. What's in the mind of this witness is not relevant to self-defense.
Sustain.
I believe it's relevant. It's not.
I sustain the objection.
Nothing further, Judge.
Any redirect?
Ms. Bush, I just have a brief follow-up. Defense counsel asked you about threatening statements, fighting statements, aggressive statements. Did you ever hear Chris threaten Mr. Bush?
I kept hearing him say, nigga what, what's up, nigga what, what's up? That's the same thing I was telling Tina. I don't know.
Other than that, did you hear Chris say anything else?
No.
Thank you. No further questions.
How old is your brother?
60. What, 32?
62 or 63. At the time of this incident, was your brother in a wheelchair?
No.
But he does have some significant medical issues that you're aware of, is that right?
Yes.
Any questions based on my question?
No, Your Honor.
Yeah. How big is Chris compared to your brother?
I have the medical examiner's record.
Judge, I don't believe that is necessarily accurate looked at that closely, so and
You
then
think her testimony is gonna be more accurate than the medical examiner who did the autopsy?
Judge, I'm just telling you what I've watched video. I watched the one officer out there compared himself, the gentleman to his size, and he's way bigger. So I'm just asking her what she saw. That's all, Judge, for the record. At that time, was Mr. Watson a bigger man than your brother?
Yes,
Was he heavier than your brother?
yes.
Thank you.
Thank you, ma'am. You may say that. Any other witnesses for the people?
Judge, I don't think it's necessary to call any other witnesses.
Any witnesses for the
No, Your Honor.
people?
Your Honor, I move for bind over as charged. I think the statement from those witnesses are pretty clear. There was an argument between the defendant and the victim in this case. It started after the defendant told him to stop driving so fast. And possibly may have said he almost hit him. The testimony is that the victim in this case got irate, made some statements to the defendant, and then left the situation, came back to the situation. There's testimony from Ms. Bush, the victim tried to open the door, the doors were locked, went around. I'm not gonna repeat, but she testified as to what the victim said, and the defendant shot him. An unarmed man, and in this case, obviously, it appears as though the defendant's gonna try and argue self-defense, but there's no evidence of self-defense now. That would be a question of fact for the jury to decide. The victim in this case was unarmed and was shot by the defendant while he was seated in his vehicle. He certainly could have drove off or, rolled up the window or ignored him, but instead chose to shoot him and then drive off. So I am moving the bind over on all counts.
Mr. Johnson.
Judge, I'm well aware that this is a serious offense. I think I was charged with homicide in the second degree, but based on the testimony of the witnesses, which I believe to be credible, I would just indicate to make some legal arguments, Judge. I would indicate that at preliminary examination, the district court must conclude, and I know this court is well aware of the law, but for the record, must consider the weight and competency of the evidence and the credibility of the witnesses and evidence in the defense. People v. Yost 468-122, 2003. See also People v. Anderson 501-175, 2018. When the defense is complete and there are no conflicting facts regarding the defense, it could be argued that there was no probable cause to believe that a crime had been committed. People v. Redden 290, Mishap 65, 2010, citing People v. Walton Nen 272, Mishap 678, 2006. However, the district court cannot refuse to bind the defendant over for trial if the evidence conflicts or raises reasonable doubt regarding the defendant's guilt, because this presents an issue for the trier of fact. Judge, I believe in this case, we have a self-defense claim, but I don't think there's any conflicting, I don't believe there's any conflicting evidence between the witnesses, what they saw, what they heard, what they felt, their honest belief, the fear. The law says that you can use deadly or even non-deadly or deadly force if you have an honest belief that you may be injured, sustain great bodily harm, or even be killed. And you have to look at whether that belief is reasonable. His medical condition kind of, his vulnerabilities kind of heightened that issue because in his mind, he can't escape, he can't run. This guy removed himself from the situation, he never responded. The fact that he simply told someone to quit speeding up and down the street, who has a habit of doing that, the testimony shows, everything kind of lines up. It lines up that he parked on one side of the street because of his mental infirmities and medical condition to get out, to make it easier to get into the house. It lines up that this guy is yelling, out of control. They can't control. He places fear even in Mrs. Danielle. She honestly said that she was even in fear. He was out of control. Never seen him act this way. Says his face turned into a beast from Miss Reddick, Miss Bush. So these are circumstances, when you look at the totality of the circumstances, how it arose. He's sitting in his vehicle peaceably. He retreats to his vehicle. This guy goes home yet and has not cooled off. We get that from the testimony. Comes back within 5 minutes and he's making gestures as though he could be armed. My client is sitting in the vehicle. He's a smaller man. He knows he can't get away from him. He knows he can't run. He knows this guy's standing over him and he shoots him. There's no established intent to kill other than firing to protect himself. And so I don't believe that second-degree murder is the appropriate charge here. I believe self-defense is a real defense here, Judge, and it may be a quantum leap that this court is not willing to take. But at the same time, there's even a charge that where it involves manslaughter, where a person causes the death, dies as a result of that cause of death.
You're better off arguing self-defense. Manslaughter does not apply here.
Well, it's not a manslaughter case, Judge. It's just where a person intentionally aims a firearm at somebody and shoots them without the intent to kill, but we don't have to go there. I believe, Judge, based on my arguments, that self-defense does apply here, and clearly there's no second-degree murder on the part of my client.
Your Honor, if I may respond. Just briefly, first, self-defense, and everything defense attorney argued, that the defendant had an honest and reasonable belief that the victim in this case was either going to cause him great bodily harm and or death. It can't be considered because there's been no evidence in this court as to what was in this defendant's mind, whether he thought the defendant had a gun or whether he thought he was in fear of great bodily harm and or death. There's none of that.
The standard is a reasonable person.
Well, I understand, but it has to be a reasonable person in the defendant's situation. And the only evidence we have here is that the victim was, I'm not going to repeat the words, but saying some words, holding, the witnesses both said he was holding up his pants and that there was no weapon visible, no weapon found. And certainly the court should bind this case over. And if he wants to argue self-defense, there has to be sufficient evidence as to the defendant's state of mind as well. And that should be left for a trier of fact.
See, the problem that you have here, and if this case gets bound over, you'll have over in the circuit court, is that the only witnesses you can proffer lay the foundation for some kind of self-defense. There hasn't been anything contrary to that. Based on the testimony I've heard, we have the defendant who is 62 or 63 years old with all these medical conditions, who merely says to the complaining witness, slow down. You're driving too fast down the street, you almost hit me. And then the complaining witness, by your witness's testimony, goes ballistic to the point to where they can't control it. He's walking over to the car. No, scratch that. I think I heard testimony that he left and then came back, pulled up alongside of him, gets out of his car, tries to get into the defendant's car, goes around to the driver's side of the door, telling him, what's up now? And at the time that he's doing this, he has both of his hands on his waistband and tugging at his pants. Now, one of your witnesses said that he was holding his pants up. The first witness said that he had both hands in front of his waistband and was pulling his pants back and forth. The question I have to consider is whether or not the defendant was reasonable in believing that he was in fear of death or great bodily harm. Now, the medical examiner's report says that the complaining witness is 36 years old, 5'9" and 140 pounds. Not a very big man, but I can't really see the defendant. The defendant was wheeled in here in a wheelchair, but he doesn't look, he looks like he's maybe 125, 130 pounds wet himself. I can't tell how tall he is, but from the way he's sitting there, he doesn't appear to be a very big man either. But the complaining witness is considerably younger than the defendant. The defendant is almost double his age. And both of your witnesses came forth and testified that they were in fear of the complaining witness. So if they're in fear of the complaining witness, and his hostility and his anger wasn't directed at them, it was directed at the defendant, how must the defendant have felt at the time?
And Judge, I'm sorry.
Go ahead.
That's an issue where the court would have to speculate as to what the defendant is feeling. You know, the defendant's the one with the gun.
No, I'm only going by the evidence that you presented.
Well, I understand.
You presented, like I say, lay the groundwork for self-defense.
But the court also has to consider other issues relative to self-defense, such as whether the defendant had not had an
One thing I have to
opportunity to
consider
leave.
is whether or not his fear of death or great bodily harm was reasonable.
Yes, and in determining whether that's reasonable, the court also has to consider whether he had to stay, whether he had means to leave the situation. He's in the driver's seat of his vehicle. He certainly could have just drove off. There's other considerations that the court has to make as opposed to, does he just get to shoot somebody because somebody's yelling outside his car, yelling at him, or for example,
Not
does
only
he have
just
to
yelling
drive
at him, but
off?
trying to get in and then saying, what's up now? What's up now? Which to me is threatening. So I look to the case of People versus Sher. It says the district court has the authority to consider defendants' defenses when determining whether to find over to certain courts. While affirmative defenses such as justification and self-defense must typically be presented at a trial, the inquiry at the preliminary exam is not limited to whether the prosecution has presented evidence on each element of the offense. Thus, if the defendant presents evidence that he or she has a complete defense to the charge on the undisputed evidence, it would be improper for the district court to bind over the defendant. So the undisputed evidence that I have is that the complaining witness was wilding out, confronted the defendant, and he was wilding out to the point to where, this isn't lost on me either. Both of the witnesses that you called are related to the defendant. They're family. And I'm sure they don't want to see their uncle, their brother, sitting there in county greens. So perhaps their testimony may have been jaded just a bit. But I'm stuck within the four corners of this hearing and what they testified to.
Your Honor, no witness ever testified that they were in fear of great bodily harm and or death. they were afraid of what he might do, but there's.
What might he do?
Well, even if it was a physical assault, even if the court were to make the jump that this defendant or reasonable person would be in fear of perhaps an assault, if he were to use non-deadly
So
force.
this is where I put myself in the defendant's shoes. And I have to put myself in his shoes. This defendant is not Kenneth King sitting here, 200 pounds, 5'9", 54 years old. He's 62, 63 years old. I don't know how much he weighs, but they tell me that his testicles are the size of grapefruits. That he's sick. Each of the witnesses testified how ill he is. And this was on the day of the incident, although he wasn't in the wheelchair. On the day of the incident, he's in one now, but putting myself in his shoes then, not a well man being confronted by a 36-year-old who's considerably out of control.
I understand that, but I would imagine somebody in that situation would then just drive off, and that's what the court has to consider.
And Judge, the
But
case-
none of the evidence here suggests that he was in fear of great bodily harm and or death. That's the complete different distinction of he didn't use non-deadly force here. He chose to shoot the victim. In order to use deadly force, which the defendant clearly did, he has to specifically be afraid of great bodily harm and or death, not just somebody challenging him to a fight. Even if he, thinks that's gonna happen, he could have driven off. But there was no specific evidence that the defendant ever threatened to kill him, to do great bodily harm, and you cannot use deadly force against a non-deadly aggressor. Even if the victim in this case was gonna cause him bodily harm, it has to be great bodily harm and or death, and I think that's why the court needs to find this case over, is that none of that evidence exists.
Judge, I believe clearly, the reason I raised the argument, because there is no evidence in dispute or conflict. Moreover, it's what the state of mind and reasonable belief was in Mr. Bush. And that can be shown by circumstantial evidence and the totality of the circumstances in which I believe this court has considered. And when you consider that, that's it. There is no other evidence that's been presented, Judge, to conflict with what we have. And that won't change whether it's here or there. So I believe the court can, based on People v. Hoskins, 403 Mishap, 95, 1978, use in this case to use circumstantial evidence in this case to establish that my client's state of mind caused him to act reasonably under those circumstances, and that he acted in self-defense. The reasonableness of his decision, Judge.
Just by virtue of the fact that we're having this discussion, probably lends itself to a question of fact to be determined by a trier of fact. But as the case indicates in People versus Shirt, I have the authority to consider the defendant's defense of self-defense. And if it is undisputed evidence that the defendant acted in self-defense, it would be improper for me to bind it over. I haven't heard anything contrary to what these witnesses testified to, that this younger man confronted this defendant, who is, again, sickly, much older. I'm just not comfortable in binding this matter over. As such, the court is going to dismiss for insufficient evidence. Thank you.
Just to be clear, first of all, for self-defense, the defendant must have honestly and reasonably believed he was in danger of being killed, seriously injured, or sexually assaulted. There's no evidence of that. Second, a person may not kill, seriously injure another person just to protect himself against what seems like threat of only minor injury, which is the only thing the court has here. And third, I don't know how the court's going to dismiss this case, because even if you were to decide that, we still have the felony firearms and a felon in possession charge and a CCW charge.
You're
Those
correct
have
in that.
nothing to do with
You're
something.
correct in that. So the case, let me clear the record. The court is dismissing the homicide, murder, second degree charge. Weapons, firearms, possession by a prohibited person. The court finds the people have met their burden of probable cause on that, as well as the accompanying felony firearm. Okay. But the homicide is dismissed for insufficient evidence. And how I arrive at that, to answer your question, counsel, this court can make, as you know, can make logical inferences based on the totality of the evidence. So based on the totality of the evidence, and this defendant being confronted again by a much younger man, and him being in the state that he's in, that I can infer based on the evidence and the witnesses that testified here, that if they were afraid, they were most certainly afraid of the same, and that he was the one who was being actually confronted. Okay, so count one is dismissed, as well as the count three, the felony firearm that accompanies count one. Court is binding over on count two and count four.
Thank you.
And thank you for that. I totally looked over that. I was only thinking about the homicides. I need dismissals as the counts one and two. I'm sorry, one and three.
Judge, can I address Bond?
Yes.
Okay. Judge, he's currently being treated at Henry Ford's. He's been in and out the infirmary constantly. He's on the transplant list. I'm very familiar with that because, as you know, I had a transplant in 2006.
Transplant what?
Liver. So I'm very familiar with that, very concerned with that. And he's not getting the treatment that he really needs at the jail. He can't eat. He just, like this week, he was just able to get a drink of water. Again, he's been in and out the infirmary. With respect to the change in the charges, he's on disability. I would ask the court, how long? He's been locked up since June 10th. I would ask the court to consider a personal bond, Judge, because based on the charges that are left, I can attest to the fact we've had a good relationship, that he will appear. I will be representing him throughout this matter. And whatever his health status is, I will keep the courts informed and make sure he appears.
Well, I do have an issue with the fact that he allegedly had a weapon with him in the first place. It was not authorized to possess one. So even with that, the court would not be inclined to give a personal bond. How much do you think you could post?
Judge, he doesn't know, but we'll take any nominal bond that this court consider. We trust your discretion, Judge.
Judge, I do believe a cash bond is appropriate, even on accounts the court's binding over one of the, as well as he's a habitual for one of the counts is certainly felony firearm, which is mandatory minimum of 2 years.
Judge, I probably will write a gun board letter on that, but he's in
I'll set bond at $5,000 cash surety with the GPS tether.
No problem, Judge.
Absolutely no weapon, sir.
Thank you.
That's gonna make his arraignment date still gonna be August 8th, 2024 at 9:00 a.m.
Very much, Your Honor. Have a good day.
Thank you as well. Folks. Okay. Are you ready, folks?
Yes, Your Honor.
Calling case 2161062, people of the state of Michigan versus Ronell Arif Bachelor. Defendants charged in count 1 operating while intoxicated causing death. Count 2 operating license suspended, revoked, denied causing death. Count 3 operating while intoxicated. Third offense notice. Count 4 temporary registration plate violations. Appearances for the record, please.
Good afternoon, Your Honor. Jaron Anderson on behalf of the people, PA 5434.
Good afternoon, Your Honor, and good afternoon to your staff. Alana Alford, P number 87128, on behalf of Mr. Ronell Bachelor, who stands to my left. Mr. Bachelor, could you please state your first and last name?
Ronell Bachelor. There's a date and time set for preliminary examination. Are we ready to proceed?
People are ready, Your Honor.
How many witnesses?
We anticipate 4 witnesses, Your Honor.
You have any preliminary matters before you call witnesses?
I do, Your Honor. Your Honor, at this time, I have the medical examiner's report as well as a certified driving record.
You may be seated.
I will move the admission into evidence of the medical examiner's report pursuant to statute, as well as the certified driving record. Those would be People's Proposed Exhibit 1 for the medical examiner's report, People's Proposed Exhibit 2 for the certified driving record.
No objection to this.
Admitted.
Thank you, Your Honor. May I read into evidence the relevant portions of the exhibits?
Yes.
For the People's Exhibit 1, the medical examiner's report. The report is authored by a Dr. Omar Reyes, O-M-A-R, last name Reyes, R-A-Y-E-S, an assistant medical examiner. Under the examination was completed on June 15th, 2021 on a Robert Lever, R-O-V-E-R-T, last name L-E-V-E-R, at the Wayne County Medical Examiner's Office. Under the summary and opinion section indicates that it is my opinion that the death was caused by multiple injuries. The examination showed abrasions on the head, chest, right buttock, shoulders, right arm, bilateral forearms, and right thigh. With respect to People's Exhibit 2, the certified driving record, the name of the individual is indicated as a Ronell Arif Bachelor, R-O-N-E-L-L, middle name A-R-I-F, last name Bachelor, B-A-T-C-H-E-L-O-R, date of birth 7/15/1985. Under the credential section in standings, it indicates that the license status is revoked. And with that, Your Honor, I have no further preliminary matters.
All right, call your witness.
Your Honor, people would call Officer Branch.
Sir, please step forward, give your name and spelling to the court reporter. Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you, sir. Please have a seat in the witness box. Thank you, when you're ready.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
Can you tell us your name again, sir?
Joshua Branch.
And Mr. Branch, are you currently employed?
I am.
Who are you employed by?
Pittsfield Township,
And can you spell the city name, please?
Township, Pittsfield.
And in what capacity are you employed by them?
I'm a police officer
And how long have you been with the Pittsfield Police Department?
since August of 2022.
Were you employed in that same capacity with that same department on June 14th of 2021?
No,
Who were you employed by on that date?
the Detroit Police Department,
And how long were you with the Detroit Police Department?
from January 2019 to August.
Now, on that June 14th of 2021, while employed for the Detroit Police Department, were you working on that date?
I was
Were you by yourself or with a partner?
with a partner.
Do you recall your partner's name?
The last name is July, I'm not sure the first name.
Okay, can you spell that last name to the best of your ability?
Jawade, if I'm not mistaken.
Now, were you in full or modified uniform?
Full uniform, Class B,
And were you on foot patrol or in a scout car?
road patrol, fully marked patrol vehicle.
Okay. And did your duties on that day take you at or near the location of Joy Road in Greenfield in the city of Detroit, County of Wayne, state of Michigan?
Yes,
Why did you go to that location?
I was dispatched to an auto accident with injuries.
And did you make it to that location, sir?
I did.
And when you made it to that location, can you tell us what you observed?
Yes, I observed paramedics and fire on the scene, loading someone onto a stretcher.
Were you ever able to obtain the name of that individual?
I was from a family member, if I'm not mistaken.
Okay, what was the name of that individual?
I'd have to look at my report.
Would looking at your report refresh your memory, sir?
Yes.
May I approach the witness, John?
You may.
I'm showing defense counsel now. Just briefly, sir, can you identify for the record what it is that I've handed you?
You handed me a police report that appears I've written on that.
Okay, so you authored that report?
I did.
Okay, so what I'm gonna ask you to do is read the report. Once your memory's refreshed, just flip that paper upside down for me. Okay, so I see that you flipped the paper upside down after having to read your report. Is your memory now refreshed?
Yes.
And sir, now do you recall the name of the individual that you spoke, or that was the name of the victim, I'm sorry?
Yes. The last name is Lever.
And the first name, sir? Withdrawn. Were you able to locate any other individuals that were involved in this accident?
Yes, I believe it's Ronell Bachelor, if I'm not mistaken.
Okay.
As well as the David Flint.
And the individual that you indicated was Ronell Bachelor, how was he involved in this accident, to your knowledge?
He was a driver of the vehicle.
And did you make contact with that individual?
I did.
Did Mr. Bachelor provide you with a driver's license?
No, he did not have an indication on that.
Did you speak with that individual, Mr. Bachelor, about the accident itself?
I did.
Did he indicate what his involvement was?
Yes, he indicated that Mr. Lever had walked into the roadway while he was driving.
And in your conversation with Mr. Bachelor, Did you have any suspicion that he may be under the influence of alcohol or any sort of controlled substance?
Yes.
Did you perform any field sobriety tests?
I offered, but it was denied.
And who denied those, the offer for field sobriety tests?
Mr. Dash.
Now, when you arrived on the scene, was there any other units there, or were you the first on scene?
I was the first on the scene, other units arrived shortly.
Okay. Do you recall the name of some of the individuals that had arrived after?
No, off the top of my head.
Did you request additional units at the scene?
There were multiple units dispatched to the scene.
I have no further questions for this witness, Your Honor.
Cross-examine.
Good afternoon, officer. So you responded to this scene, correct?
I did.
But you did not witness a collision at any time.
I did not witness it.
When you arrived, Mr. Batchelor was not behind the wheel of the car, correct?
He was outside of the vehicle.
But he was not behind the wheel of the car.
Correct.
He was not operating the vehicle. So on direct, you stated that you spoke with Mr. Batchelor, right?
Yes.
And you approached him, correct? And another officer was already standing there with Mr. Batchelor.
Correct.
And the other officer asked, were you driving? Is that yes?
I don't know exactly what he asked him.
Would reviewing your body worn camera from that night refresh your recollection? Join the opposing counsel. May I approach the witness, Your Honor?
You may.
Officer, this is your body worn camera. This appears to be your name. This appears to be from the night of question. Doesn't appear to be altered or changed. I'm going to play this starting at 5:42 to the record. That will play the relevant. And stopping at 5:50. Has your memory been refreshed, officer? So the question was to Mr. Batchelor, were you driving?
Right.
And then in response, Mr. Batchelor said,
Objection as to hearsay.
I'll move on, Your Honor. So let's talk about the circumstances surrounding this conversation with Mr. Batchelor.
Okay.
So when you arrived, you said you were the first officer on scene, but there was clearly another officer on scene.
Same control.
Yes. Other officers came very quickly after. Would you say this was a heavy police presence?
In comparison to the other ones that I remember from Detroit,
Traffic was blocked off though.
yes.
Okay. So you approached Mr. Batchelor, correct? After interviewing an alleged eyewitness.
Correct.
At this point, you were conducting an investigation, correct?
Correct.
So when you approached Mr. Batchelor, you were armed, correct?
Correct.
Okay, and the other officer, your partner, was armed too. So it's fair to say that Mr. Batchelor was not free to leave the scene when you were speaking with him, correct? You had not read Mr. Batchelor his Miranda rights at this point.
Correct.
So you spoke to Mr. Batchelor again on scene a few minutes later, correct? Would viewing your body worn camera footage from that evening refresh your recollection?
Yeah.
May I approach the witness, Your Honor?
Yes.
Officer, this appears to be the same clip, correct? Not changed or altered in any way. So I'm playing from 30 minutes, 18 seconds. I'm gonna rewind just because the connection was bad on that one. So starting the video at 26 minutes, 34 seconds. Has your recollection been refreshed, officer? So you spoke to Mr. Batchelor at another point in time during the investigation, correct? And before this happened, you had detained Mr. Batchelor, correct? And your partner had placed him in handcuffs, placed him in the back of a cruiser. So during the second conversation with Mr. Batchelor, you asked Mr. Batchelor if he had been drinking, correct? And he responded,
Objection, as the ear said.
Your Honor, we're not going into the contents of what was said, just that my client responded to the question.
Okay, I thought you were asking for his response.
No, I said my client responded. And then you told him that you were going to take him down to the station, correct?
Right.
Okay, to do a breath test. So then you placed him back into the vehicle again, correct? And still you had not read him his Miranda rights at that.
Correct.
So according to you, Mr. Batchelor seemed intoxicated, is that fair to say?
Yes.
But you did not administer PBT on scene.
Correct. I was not treated.
Okay, and you did not conduct a field sobriety test.
Correct. Mr. Batchelor refused.
Okay, so let's talk about what you did observe from Mr. Batchelor.
Mhm.
You did not smell any alcohol on Mr. Batchelor's breath, correct? So your testimony today is that you smelled the odor of alcohol on Mr. Batchelor's breath.
If memory serves correct.
Officer, you wrote a report of this incident, correct?
Correct.
You were truthful?
Yes.
Honest? You included important details because you knew that this would be used in some sort of prosecution possibly in the future? If I showed you this report, would you recognize it?
Yeah.
May I approach the witness, Your Honor?
Right.
Officer, this is your report. From the date in question,
Can you voice up for me, sir?
Yes.
does it appear to be altered or changed in any way? So if you could you just please look at this police report and tell me where you see that you had noted you observed the odor of alcohol on Mr. Batchelor's breath?
It's not.
So to be clear, you did not note that you observed the smell of alcohol on Mr. Batchelor's breath. You also did not notice that he had bloodshot eyes.
I did notice it's also.
I didn't hear you.
If I did notice, it's not noted.
So it's not noted in your report.
Correct.
Okay. You did not note that he had watery eyes.
Correct.
You did not note that he had droopy eyes. You did not note that you observed any open containers of alcohol in the vicinity. You did not see any containers of liquor, period.
Correct.
You did not see him stumble.
That's not.
You did not see him fall down.
No.
You did not observe any slurred speech. Did you note any slurred speech in your report?
I did not.
So the only thing that you noted in your report that you personally observed was that Mr. Batchelor was leaning against his vehicle. Mr. Batchelor was standing next to some sort of an SUV that evening, correct? But as part of your investigation, you did not personally inspect the vehicle for damage.
I did not.
So that's a no.
Correct.
You did not note finding any debris on scene.
I did not know.
You also did not note finding any blood on the car, correct?
Correct.
You were also present when Mr. Batchelor did a data master breathalyzer test at DDC, correct?
Correct.
You're not a certified operator, for example. Okay.
Not at that time.
No further questions.
Can you redirect?
Just very brief, Judge. When you arrive on scene, sir, is it part of your duties to collect evidence the second that you get there?
No.
What are your sort of concerns when you first get on the scene for an auto accident involving injuries?
The first priority is preservation of life. The second priority is the security of the scene.
And is it fair to say that, determining if there's blood on a vehicle is neither of those concerns?
Not immediately.
Not an immediate concern, is that fair to say?
Yes.
Thank you. No further questions, Judge.
Okay, so officer, set the stage. You get called to this scene, have a person, at the time that you arrived at the scene was the deceased on the scene?
Correct.
Okay, so the deceased was there, and what is your objective once you arrive at the scene?
The first objective is to protect any sort of life, preserve any life that's still on scene. I did observe medics and fire already loading the individual into the ambulance.
All right, so at this stage, are you in investigation mode, or are you trying to just determine who's who and who saw what?
At that point, I'm concerned with the scene security and determining who saw what, who's involved, essentially.
When you encounter the defendant, is the defendant the subject of your investigation?
Based on the witness statements.
Okay, so you already indicated that at the time that you talked to the defendant, he was not free to leave, is that right? And he was placed in handcuffs?
After it was determined that no ID.
After it was determined he had no ID? Okay. And you began to ask him questions about him being the driver and what happened?
I think my partner asked if he was the driver.
So why wasn't he read Miranda before you began asking questions? He was in custody and not free to leave.
Can't answer that right now, just because of how long ago this was. It's been quite a few scenes since 2000.
Understandable. Can you give me any reason or any reasonable explanation as to why he was not read Miranda?
At this time.
And you tell us about so you arrested the defendant. Was the defendant under arrest for not having the license?
The defendant was under arrest for the critical injury accident, no license, and suspicion of identifying.
All right, why did you suspect that he was operating while intoxicated?
If memory serves correctly, not only was I informed by a witness that he had slurred speech, I can also see on the video that he had slurred speech last in the eyes.
All right, why did you know any of that in your report?
This is a very early portion of my career with policing, and that is one of, if I'm not mistaken, one of the first interview lives I had. At that point, it was not so.
Although you did not indicate it in your report, do you have any independent recollection that he had glassy eyes and slurred speech and so forth?
No,
No. So how can you testify that he did in fact, because you don't have a report that references that?
it was solely on the camera.
Sorry,
It was based off the camera footage that I was seeing.
camera footage that you were?
That was shown to me.
Oh, so you were you saw some camera footage before you came here to testify?
No, what the defense counsel.
Oh, I see. And just now?
Yes.
You were able to see the defendant?
Yes, I could see his face as well as I could hear the slurred speech.
Would that refresh your recollection?
Yes.
Any questions based on my question?
Just a couple of clarified questions, if I may, Judge. So, Officer Branch, when you first approach Mr. Batchelor and ask him questions, had you already placed him in handcuffs at that time, or was he walking about that?
He was walking about.
Okay, so he was not under arrest the first time that he spoke?
Correct.
Okay, you had earlier indicated that he wasn't free to leave, but is it fair to say that he wasn't under arrest?
At that time, yes.
Thank you.
So Officer Branch, you say that this was a long time ago, correct?
Yes.
So 2021, right?
Yes.
Which is why you can't remember why you didn't read him his Miranda rights.
Correct.
But somehow, even though this was 3 years ago, you still remember he had glassy eyes.
That was based off the camera footage that you had presented.
So you were able to see on that footage that he had glassy eyes.
Based on the lighting, yes.
How could that be? Based on the lighting on the scene?
Yes, based on the lighting on the scene with the camera footage, the eyes are extremely shiny. Is the best way that I can describe it.
So the video was that clear.
It's not extremely clear, but I can definitely tell it's more on a reflective surface, very similar to the car.
And there was ample overhead street lighting on the scene.
Objection as to ask and answer at this point.
Was there ample street lighting at this time?
It's not ample, no, it's based on the reflection of the blue and red of the reflection.
So were you facing, how far apart were you from Mr. Batchelor during this time?
Maybe 5 or 6 feet.
And you were looking at him directly in the eyes? The entire conversation?
Not the entire conversation.
So that was, if that was clear on the video, I would just like to ask again, why did you not indicate it in your report?
Due to the earliness of the career of OWIs that I had, it did not seem, or I did not have it, because it's a very new scene.
And again, your testimony today is you had no independent recollection of those indicators of intoxication. Thank you.
Anything else?
No, Judge.
Thank you, sir. You may step down.
Yes, Your Honor. People would call Sergeant Fitzpatrick.
Please read your name and spell it to the court reporter. Raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please have a seat. You good first? And again, when you're ready.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
Can you tell us your name again?
David Fitzpatrick.
Employed, sir?
Yes, I am.
Where are you employed by?
The Detroit Police Department.
And in what capacity?
As a sergeant of the RC unit.
And how long have you been employed by the Detroit Police Department?
11 years.
Were you employed in the same capacity that you are today on June 14th of 2021?
No, I was not.
What were you employed by the Detroit Police Department at that time?
Yes, as a sergeant on patrol.
Okay, so you were a patrol sergeant on June 14th of 2021?
Yes.
Were you working on this date?
Yes, I was.
Now, sir, on that date in question, June 14th of 2021, did you receive any specific requests?
Yes, as a patrol sergeant, I received a radio request to be a scout at the DDC, our jail, to do a data master.
Okay, DDC, can you tell us what that stands for?
Detroit Detective Center.
Thank you. And the task that you had indicated, can you tell us again what that was?
It's the data master evidentiary breath test.
And can you tell us just briefly what a data master breath test is for?
Yes, it's to test the breath alcohol level of someone who's under arrest for OWI or one of those related offenses.
And how was that test performed?
It's a breath test, so the subject would blow into a tube that is then calculated by a computer to get results.
And is there a method that you guys use to ensure that the system is calibrated?
Yeah, before each breath test and before the final result is printed out, it does self-calibrate every time.
Okay. And do you know how the machine self-calibrates?
Specifically, no, it's all an internal mechanism that it does.
Okay. And is there, as you're using the system, is there a way that the system shows that it's been calibrated?
Yes, it'll show on the final printout.
Now, does the use of the data master test require any formal training or certification?
Yes, it does.
What kind of formal training and certification?
Data master level 2 class at the time, taken at MSD.
Okay. And is that generally what's required, or is that the training that you've undergone?
That was generally required at the time. Now that we've upgraded to a new system, it's a different class, but that's the class that we were required to have at the time.
And did you possess that certification?
Yes, I do.
When were you trained in that?
2016.
Okay. And did you have the level 2 requirement that you indicated was required?
Yes, I did.
Okay. So I'm gonna take you back to the day in question. Did you perform a data master test on that day?
I did.
Do you see the individual that you performed the test on that day in court today?
I did.
Can you point to that individual and identify her clothing that they're wearing?
Yes, he said that the defense table on a black polo shirt.
Your Honor, may the record reflect the identification of the defendant by the witness?
Someone.
Okay. Now, prior to administering that test, what did you do?
Read the subject, the chemical test rights on the DI 177, and then observe the subject for 15 minutes while I enter the subject's data into the data master computer.
Okay, when you say subject, who are you referring to?
The defendant.
Okay. Did you read the defendant his chemical test rights?
I did.
And after reading his chemical test rights, what, if anything, did the defendant say in response?
He agreed to take the test.
Okay, so is it fair to say he was willing to waive those rights and complete the data master test?
Yes, complete the test he did.
And can you walk us through the first step of administering the test?
After reading the chemical test rights, I would put all the data information into the data master. Data master will then self-calibrate, and once it's ready to begin the first test, it'll start beeping at me. At that point, I put the mouthpiece on and give it to the defendant to administer the test.
And prior to administering the test, I believe you indicated earlier that there's an observation period.
Yes, 15 minutes.
Okay, did you complete that
Yeah.
test given to the defendant?
Yes, I did.
Okay. And anything of note in that would have concerned you as to the results of the data master?
Not that I recall.
And you indicated that the machine will beep when it's been calibrated and ready?
Yes, that's very good. He's dependent to go into the machine.
Okay, did that occur in this case?
Yes.
And after you hear the beep, what do you do?
Give the defendant the straw, the mouthpiece with the straw attached to it. He blows into the tube. Once the machine has received enough sample, it'll stop testing.
Okay. Is there anything that the machine does to indicate that it's had enough of a broad sample?
It'll stop beeping, or all the will stop.
Okay, so as the individual, in this case, defendant is flowing into the machine, there's an audible beep while he's doing that, is that fair to say?
Yes, that's correct.
And once that beeping stops, the machine has had a big enough sample?
Yes, then it'll test the sample, then auto recalibrate, and then prepare for another sample.
Okay, and did that occur in this case?
Yes, it did.
And did you, again, do another sample?
Yes, I did.
Now, after you complete the test, are you provided with a paper printout of the results?
Yes, I am.
And if you saw that paper printout, would you recognize it, sir?
Yes, I will.
Your Honor, I have People's Proposed Exhibit 3, which is provided to the defense and shown now. Any questions?
Okay.
Sir, can you identify for the record what it is that I've handed you?
As the data master test report.
Okay, and on the top of it, what leads you to believe that this is the data master from the one in question?
The date, time, and location, which is 6/15/2021 at 1:35 in the morning at the Detroit EDC. Has the subject's name and my operator number and badge.
Okay, and the subject's name, what does it indicate is the subject's name?
Ronell A. Bachelor.
Your Honor, people move into evidence, move for the admission into evidence, People's Proposed Exhibit 3.
Your Honor, I would object to this. I don't believe that the foundational requirements have been met under People versus Kurlatowski. I don't believe that the foundation has been laid as to the reliability of this testing device, as well as the method and procedure followed for operating this machine.
Judge, I would first state that obviously a foundation has been met, he's indicating that this paper printout indicates that it fairly accurately represents the results of the test that was given. As it relates to the procedures, the officer has testified that he is a certified data master, is certified administering data masters, he indicated that the observation period has been completed, that there was 2 tests, there's nothing more that's required under the law, and he complained of unreliability, goes to his weight, not to as to his disability. So, sir, looking at People's 3, does it indicate what the first testing result is?
Yes, it does.
So, does it also indicate when the machine has been sort of calibrated, that pre-calibration check you talked about earlier?
Yes, it does.
Okay, and what does that show? What does it say?
So it shows a blank test at 1:36, the internal standard check, which is the verification at 1:37, then the subject sample at 1:37 at a 0.26 BAC.
Okay, and the calibration sample, does it say what the results are of that calibration sample? The numbers associated with it?
No, the blank tests are at 0 BAC.
Okay, and then the second test, is that the subject sample then, the one given by defendant?
Yes,
And what is the result of that?
0.26.
Okay, and you indicated that there's another test that's performed, but in between there, is there another test that's conducted?
Yeah, so the next one is a blank test, again, making sure that the machine's calibrated correctly at 0.00. And then the second subject test, which is a 0.26.
Okay. I have no further questions, Your Honor.
Crossing that.
So officer, you are certified to operate this machine, correct?
Yes, I am.
So let's talk about how you can ensure these machines are accurate. I'm not talking about calibration, but about accuracy. This is an evidential correct machine, correct?
Yes.
Okay. And it must be verified for accuracy at least once a week.
I'm not certified to explain that procedure.
You're not qualified to explain that procedure?
No, that'd be by a data master or technician.
So you cannot speak to whether this machine was properly tested for accuracy.
That is not part of my job, no.
So that's a no.
No.
Are you aware that the records of an accuracy check must be kept on file
Yes,
by ZPD?
yes, at the DEC.
And you don't have those records with you today?
No.
So you cannot say before June 15th, 2021, when this machine was tested for accuracy?
Objection asked and answered. And he's already indicated he doesn't perform these, he wouldn't have personal knowledge of that.
I can move on, Your Honor. So on top of accuracy checks, these machines must also be inspected every 120 days, correct?
Again, not something I would know about.
So something you can't speak of, correct? Okay. Let's talk about calibration because you did testify about that on direct. This result sheet, nowhere on this sheet does it say the word calibration on it.
No, it says internal standard verifies how it's checking itself to make sure it's accurate.
Understood. And you also testified on direct that you were unsure about how the internal mechanism works to calibrate the machine.
Correct. That's again not my level of expertise.
You just receive some sort of beep or you receive a notification from the machine that tells you.
Yes.
So you're relying on the machine to tell you that it's calibrated, correct?
Correct.
I would like to focus on the 15-minute observation period that you testified about. So you personally observed Mr. Batchelor for 15 minutes?
Yes.
Okay. And that's to ensure he doesn't put anything in his mouth, correct?
He doesn't eat, regurgitate, or have any blood in his mouth.
Because that could skewer the accuracy of the results.
Yes.
You didn't see anything enter his mouth during this period.
No.
Where exactly did you observe Mr. Batchelor? Was it in the same, I'll rephrase. Did you observe Mr. Batchelor in the same room in which the test was conducted?
I can tell you what that done at the DDT. I'm not sure it was in the same room or in the hallway while we were processing and getting into that room.
So you received a call that night to come to DDC to perform the test.
Yes.
And that you said that was about 1 a.m.?
I did not say one.
You wrote a police report of this incident, correct?
Yes.
Were truthful in that report?
Yes.
Honest?
Yes.
You would, with this refresher recollection, if you were to view this report as to when you received that call?
Yes.
Mayor Pro Tem. Sergeant, this is your report?
Yes.
Was it investigation, any questions?
Correct.
Does it appear to be altered or changed in any way?
No.
Please review the report, and when your recollection has been refreshed, please look up. So when approximately did you receive a call to come to the DDC?
Approximately 1 a.m.
So you were not at DDC, then, it's fair to say.
No, I was not.
Do you recall how far away you were?
I was somewhere in the 8th precinct, my patrol zone.
So how many minutes approximately would it take to get there?
Objection as the relevance.
What was the question again?
How long would it take to get to the DDC? From where he was?
I would also note this officer hasn't testified that he was the one who transported the defendant to the DVC, so I don't see the relevance of this.
I am asking as to when this officer arrived and how long it took him to get to the DDC. I'm trying to establish that the 15-minute observation period did in fact occur. So that is why I'm asking how long it took for him.
And traffic and where I was at the time. 5 minutes.
15 minutes. So generously speaking, 15 minutes to the DDC. The data master results show you when you do when the subject first blows, correct? The time?
Yes, when the first sample was taken.
And this first sample was taken at 1:36, correct?
That was the blank test. His first sample was at 1:37.
1:37. Okay. So it's fair to say that you arrived at approximately 1:15 in the morning at DDC, correct?
Approximately.
And that you observed this individual for approximately 15 minutes?
Yes.
And then you administered the results 7 minutes later?
Yes.
So we're talking about the data master GMT model specifically, correct?
I believe so. I'm not sure the exact model number of it.
The DMT though, is that fair to say? Okay. Is that the machine DPD still uses today?
No, it is not.
Are you aware that the Michigan State Police launched an investigation into the data master?
Judge, first of all, this witness's awareness of any of this is irrelevant, and I believe defense counsel is testifying. this point.
I'm asking about his own personal knowledge as to an investigation. He can say yes or he could say no.
I would again state that his awareness as to anything that has occurred is irrelevant. His awareness of these things is not an issue in this case.
Your Honor, I just would say that it is relevant because it goes to the accuracy of these tests. Are you aware that the Michigan State Police launched an investigation into the Data Master DMT?
Yes, I am.
And that investigation dealt with flawed test results.
I'm not really sure the entirety of the scope of the investigation.
Are you aware that investigators found irregularities with the DMT devices at DBC specifically?
Yes, for a certain period of time, they were taken out of service and then re-entered into service.
And that they were removed in 2021, correct?
I couldn't tell you the exact dates.
No further questions.
You redirect? Thank you, sir. You may step down. Next witness, please.
Your Honor, people call Sergeant Warner.
From the back. So the whole truth and nothing but the truth, so it's got.
I do,
It's
yeah.
been a long day. Maybe, yeah, we're ready.
Thank you, Your Honor. Good afternoon, sir.
That,
Can you tell us your name again?
Paul Warner.
And are you currently employed, sir?
I am.
Who are you employed by?
I'm employed by the city of Detroit Police Department.
And in what capacity?
I'm a sergeant with Fatal Squad, which is under homicide and SWAT.
Okay. And can you tell us what Fatal Squad is?
It's a unit that investigates all fatal critical crashes, operating while impaired, felony offenses, any accident deemed by the chief of police.
Okay. And how long have you been with the Detroit Police Department in total?
I'll be done with my 28th year
And how long have you been with the fatal unit?
since November of 2013.
Thank you. Now, were you employed in this capacity on June 14th, 2021?
I was.
Were you working on this date, sir?
I was recalled, yes.
Okay, so you were off duty initially on that day?
Yes.
And you said you were called?
Yes, I'm on 24-hour 7-day operation.
Okay. Did you receive a call on that day?
Yes.
Now, did your duties as a police officer take you at or near the location of Joy Road in Greenfield in the city of Detroit, County of Wayne, state of Michigan?
Yes.
Why did you go to that location, sir?
There was a crash involving pedestrian.
And did you make it to that location?
I did.
And when you made it to that location, what are your some of your duties when you initially arrived on the scene?
Sir, you have to step out, no shorts allowed. Okay.
Thank you. I'll re-ask you that question. When you arrive on the scene, specifically the scene we were talking about earlier, what are some of your duties when you first get there?
I make direction to my team, evidence to identify parties involved, and then field sketch photographs are normally taken by Cranston Services for my team.
Okay. And you had mentioned the field sketch. Did you complete a field sketch in this case?
I did.
And if you saw that field sketch again, would you recognize it, sir?
I would.
The Honor, I have People's Proposed Exhibit 4, which will show the defense. May I approach the witness?
May.
Sir, can you tell us what it is that I've just handed you?
This is a table of measurements and a field sketch that I completed for this incident.
Okay, and how many pages are there total?
2.
Okay, is that the sum of your field sketch?
Yes.
Okay, is it fairly and accurately reflect the field sketch that was done for this case in this day?
There's a copy with exhibit sticker.
Okay, but is it fairly and accurately, is any changes from the field sketch that you completed?
No.
Okay, so it's substantially the same condition, is that fair to say?
It's a copy. Yes.
Okay, thank you. People move for the admission into evidence of People's Proposed Exhibit 4.
No objection.
Admitted.
Now, Sir, in the field sketch on the second page, can you just tell us generally what we're looking at?
The second page is a sketch showing an intersection and locations of items that were identified as evidence, which would be listed on the table.
And the information that's conveyed in the field sketch, where are you getting that information from?
From the scene.
Okay, so is it fair to say you're not just making this up in your head, this is stuff that you're seeing on the scene?
Yes.
Okay, and the first page of the scene sketch, what does that contain?
That is the table of.
Okay, and is there a sort of index on there as well?
Yes.
And do the numbers associated on the index correlate to the numbers that are on the second page?
That's correct.
And I'll ask you again, so the field sketch, this is People's Exhibit 4, is that fairly and accurately reflect the scene as you came upon it that day?
It's a log of the evidence that I identified.
Okay, and that fairly and accurately reflects where you found that evidence, that sort of thing?
Yes.
Now, sir, if you saw a picture of that scene, would you recognize it?
Yes.
At People's Proposed Exhibit 5, they approach the witness.
You may.
Now, looking at People's Proposed Exhibit 5, can you identify what that is?
This appears to be a Google photo of Joy Road, looking in the western direction towards you.
Okay, and sir, that photo, is that location there, does it have any significance for this case?
Yes, it would be location of it, which was Joy Cross.
And that photo that your People's Proposed Exhibit 5, does that fairly and accurately reflect the scene?
I would say no, because this is not.
Okay, but the location generally of where the scene that you're at, is it fairly and accurately reflect the location?
This is a photograph of the intersection that I responded to where the accident occurred, not where that day.
Okay, so it doesn't reflect the scene as you saw it on that day, but it reflects the location generally, is that fair to say?
Yes.
People move for the admission into evidence, People's Proposed Exhibit 5.
No objection.
Admitted.
Now, sir, looking at People's Proposed Exhibit 5 as well as, or, so I'm sorry, People's Exhibit 5 and People's Exhibit 4, can you tell me where sort of some of the debris, items of victims' clothing, that sort of thing was found on the scene?
From your Exhibit 5, which is the assuming Google board, you're looking westbound on Joy from Press. On the sketch itself, it is directing evidence is west of Press towards me.
Okay, and the sort of collection of some of the victims' items, are they in a particular lane in the Exhibit 5? Is it in the far right, the middle lane, the turn lane there, or the far left?
On the sketch itself, you have a vehicle and one item in travel lane, westbound travel lane. Other items are identified in the left.
Okay, and that left turn lane, is that a lane of travel or a lane dedicated just for turn?
That is the left turn lane, which does break a little bit past Press from where people can enter east and west, where no yellow lines are to the left turn.
Okay. And is there an intersection that you see on there, sir? Like, I'm sorry, not an intersection, a crosswalk?
There's sidewalks leading to the roadway is an unmarked crosswalk.
Okay. And by unmarked, can you tell us what you mean?
A marked crosswalk, there would be lines showing that you could be.
Okay, that would be lines in the roadway.
Yes, going across from sidewalk to sidewalk.
Is there anything else in the photo that indicates that this is an area for pedestrians to cross?
The sidewalk has the handicap red bumps on each of the sidewalks. On the photograph, you can see them going north and south, and also you can see them on the westbound side.
Thank you. So the evidence that you find from the victim, the shoes, the various items that are marked in the field sketch, and again, looking at People's Exhibit 5, is it fair to say that the victim was traveling through a crosswalk at the time it was said?
It's possible.
Thank you. Now, sir, did you complete any other work in this case?
I did.
Were you requested to do a CDR download?
I was requested with the search warrant to download the event data recorder, CDR software.
Okay. So you indicated earlier you had a search warrant. Did you get a search warrant to retrieve this data?
Was one obtained.
Yes, okay. And that was prior to you getting the data?
Yes.
And did you complete the download?
I did.
And the download, was that completed of some random vehicle or a vehicle that was relevant to your investigation?
The vehicle that was from the witness.
And sir, if you saw a copy of that CDR report again today, would you recognize it?
Yes.
Your Honor, I have People's Proposed Exhibit 6. May I approach the witness?
Yes.
Sir, can you identify what it is that I just handed you?
It's a 9-page CDR report.
Okay. And is that the CDR report from the one that you did for this case?
Yes.
Is it fairly inaccurate to reflect that report?
There's a copy with your exhibit number 6 on.
Okay. People move the admission and evidence of People's Proposed Exhibit 6.
No objection.
Admitted.
Thank you. Now, sir, in the Exhibit 6, what sort of information can you get from the CDR?
In general, for the event data recorder reports, you can get speed, braking, other vehicle information, ignition cycles, is a deployment or non-deployment event. Yes. Depending on the vehicle, has additional information or less.
Okay. So this information that's collected, what sort of triggers this information collection?
The vehicle deciding if the airbag is going to deploy or not.
And is there an event reported in the CDR in this case, Exhibit 6?
Yes.
I'm going to direct your attention to a specific page here. Is there a section within the CDR that indicates whether brakes are being used though?
Yes.
And can you tell us for the record what page you're looking at?
This would be page 3 of that.
And the event data, does it record continuously, or is there sort of a time interval for when it records the state?
This vehicle records 2.5 seconds prior to the event.
Okay. And is it just one single event, or does it record multiple lines of data? Do you need me to rephrase my question?
That's a confusing question.
Sorry. So the 2.5 second mark, is that the only piece of data it collects, or does it also collect data from 2 seconds, 1.5 seconds?
This vehicle does 2.5 seconds prior, and every half second up to a half second prior.
Okay.
To the event.
And looking at that data on page 3, is there any point at which the brakes are ever active on this vehicle?
No.
So at 2.5 seconds, is the vehicle braking?
No.
2 seconds?
No.
1.5 seconds?
No.
1 second?
No.
And half a second?
No.
So is it fair to say that the CDR does not, the CDR indicates that the brakes were never, the individual driving never used the brakes prior to the accident? Is that fair to say?
The report indicates brakes were not applied based on.
Thank you. I have no further questions here.
Cross-examine.
Good afternoon. Let's start with the CDR retrieval report. Does this in any way show how fast the car was traveling?
It does.
And how fast was the car traveling on the speed?
There's actually 5 speeds on there. Would you like them all?
Closest to the time of the crash, please.
Can't tell you close to the crash. I can tell you based on the event.
Based on the event then.
Yes. That would be 38 miles per hour.
Are you aware of the speed limit in this area, Joint Press?
Okay.
I would also like to talk about the location of where this accident occurred. So it appears, based on People's Exhibit number 5, that we don't see a crosswalk, correct?
There's not a marked crosswalk.
Not a marked crosswalk. So it's fair to say that you don't know if the pedestrian is using the crosswalk at this time.
Based on the evidence, I cannot tell you where that victim was standing or walking.
Thank you. And then finally, I would like to talk about some of the evidence that you observed on the scene. So in the report that the prosecutor shows you, you noted on your report that you found debris, correct?
Right.
From the vehicle.
Yes.
But it's fair to say that you could not link the debris to the vehicle in question, right?
Did I personally match them up? No,
Yes.
I personally did.
So the answer is no. Correct?
I can't tell you if somebody else did, I can tell you I personally did not.
Thank you. So that's it. And you also noted that there was blood at the scene, correct?
Yes,
And you did not personally perform any DNA testing.
that's right.
And there's no way, based on what you saw at the scene, that you could determine how long that debris had been there, correct?
Based off the investigation, I can tell you it wasn't there before because of data that I observed during the investigation.
Thank you.
Anything else?
No, you're right.
Thank you, sir. You may step. Thank you. Any other witnesses?
One final witness, Your Honor. Your Honor, you would call Detective Owen.
Good afternoon, sir. Please give your name and spelling to the court report.
Yes, sir.
Swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Thank you, sir. Please have a seat. Thank you.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon, sir.
Can you tell us your name?
Donald Owen.
And sir, are you currently employed?
Yes, sir.
Who are you employed by?
I'm a detective with the city of Detroit, currently assigned to the ABER unit of the police department.
And the ABER unit, is that an acronym?
Yes, sir. Audio Video Evidence Response Team
And how long have you been with the ABER team?
since 2017,
And how long have you been at the Detroit Police Department?
over 25 years.
Have you worked as a police officer anywhere else?
No, sir.
Now, were you employed with the ABER section on June 14th, 2021?
Yes, sir.
And where were you located at on that day, sir?
I work at headquarters, sir. We go in and out, but I was at headquarters.
And at headquarters, do you have access to any sort of technology or video or anything like that?
Yes, sir.
What sort of stuff do you have access to?
All the green light cameras, city cameras, mild vision cameras, the traffic cameras that are located. We have access to the camera systems within the city of Detroit.
Okay, and do you have are you able to monitor these even live?
Yes, sir.
Okay, and do you have the ability to remote download video from these sources?
Yes, sir.
Now, on that June 14th date, Did you receive a request to locate some video, potentially download some video?
Yes, sir.
Do you recall the location that request was for?
15401 Joy Road.
Okay. And were you able to locate some video from that location?
Yes, sir.
Were you told specifically what you were looking for, time frame, anything like that?
Yes, sir. That's provided by the OIC of the case. They fill out a form, a supplement smart sheet form, and it tells us exactly what they would like.
Okay. And on this, at this 15401 Joy Road location, prior to downloading, do you do anything to verify that the timing of everything is correct?
Within the Gentex system, the timing is usually still correct unless it's a 4-hour offset. And that's usually done when they do a software update, because these cameras are updated from Sweden of all places.
Okay.
But on that particular day, the cameras were.
Okay, when you say on, does that indicate that the time that was portrayed on camera is accurate to, say, the world clock?
Yes, sir.
Okay. Now, sir, have you, you earlier indicated you were able to find some video from that location at 15401 Joy Road?
Yes, sir.
And if you saw that video again, would you recognize it?
Yes, sir.
And back, sir, have you had an opportunity to review the contents of the thumb drive I'm holding in my hand?
Yes, sir. I also have a copy of my own from Arthur,
Okay.
the original file.
And when you were able to locate, or when you were able to view the contents of the thumb drive marked as People's Proposed Exhibit 7, can you tell us what's on there?
It's a video, I believe the camera name was Overview, but it's a camera from 15401 Joy Road.
Okay. Is there one single camera angle or is there multiple camera angles?
I believe that location has 5 camera angles.
Okay. And when you were able to view the video, does it fairly and accurately reflect the video that you downloaded from 15401 Joy Road?
Yes, sir.
Your Honor, people move the admission into evidence of People's Proposed Exhibit 7.
Any objection?
I would like to view exactly what. No objection.
And then,
And Your Honor, how would the court like to view the video? Would you like to play that, sharing my screen on Zoom?
yes. Bring it in. And thank you. You should be all set.
Thank you, Judge. Your Honor, may I publish the exhibit?
Yes.
For the record, starting at 0 minutes, 0 seconds. Your Honor, I paused at 31 seconds. I would like to replay that 30-second. Again, starting 0 minutes, 0 seconds. pausing at 31 seconds. I would note for the court, if the court would like to see the video in a little more detail, I can bring my laptop.
Officer, this exhibit that people is showing, what is this depict? What street is that, and what parking lot?
That is from the location of 15401 Road. It's one of the green light cameras that's connected to the building.
Now, is there anything about this particular video that drew your attention to something?
Well, the video is quite dark, but up in the top, right to the right side of the white building with the light on, you can see an individual walking. And then you can see that individual being struck by the vehicle.
Okay, so your attention was drawn to the upper right corner of this video, where that light is?
Right behind that white vehicle, that white looks like a Chevy from here.
Okay.
Right to the right of the timestamp. You'll see it's really dark. I can make you a demonstrative if the court needed one, where we lighten that up, but we typically don't do any clarification on video unless requested to do so.
Can you replay that again, please?
Yes, Judge. 0 minutes, 0 seconds. Again, pause 31 seconds.
Let me see your laptop.
Yes. Hey, Coach Lawyer.
Sure.
Good, all right, sir.
No, sir.
Oh. I got it. Thank you. I was looking in the wrong place.
And just for clarity of the record, defense counsel and I did approach the court with the video on my laptop, show again the court the relevant portion. Your Honor, I have no questions, further questions for this witness.
Cross exam.
Officer, it was extremely dark that night, correct?
Yes, ma'am.
So based on the video that you were able to pull from this business, you're not able to see a license plate on this vehicle, correct?
No, ma'am.
You're not able to determine the make of the car
No, ma'am.
or the model of the car.
No, ma'am. Not for me. I was never asked to do that. I was asked to just download the video.
But based on what you see in this video, you can't determine who's driving the car.
No, ma'am.
Thank you.
Can you redirect?
Very brief, Judge. So why pull this video?
The videos, the unit that I'm in, we're trained to work with video. The OICs of the cases, to testify to video, there's more than just looking at a video. You have frame rate, resolution, there's a lot of aspects about video. So our unit is tasked to do that for the OICs of the case, so that there's no issues in court.
this location's, I guess, let me rephrase my question. Why this date, why this location, why pull the video from here?
It was pulled for an accident.
Okay, so was information communicated to you on what to look for?
I don't believe so, sir, because usually it's cameras and time frame, and that's how we work. I really don't want to know what's going on because I don't want to introduce any kind of biases into what I'm doing. So I just give me what I'm looking for is what you want, like time frame and cameras.
Okay, so this specific time, then, is this just a random chunk of time, or is the reason why you pulled camera footage for about 7 minutes from this chunk of time at this specific location? Why not pull it 8 blocks down the road 2 years ago?
Well, it's pulled for the actual the case number that pertains to the crime or issue that happened on that particular day.
Okay.
The OIC determines the evidentiary value of what they would like, and I'm the one to extract the process.
So when you watch this video, is it fair to say that it was something that led you to believe that the officer in charge might need this video?
Yes, sir.
Okay, and what is it that you observed that led you to believe that?
Someone was struck by a vehicle.
Thank you. And sir, the location, is this a random location in Detroit, or were you given a specific location to look generally for the video?
Specific location.
Thank you. And did that correlate to the location of the accident that the officer in charge communicated to?
Yeah, when they do the request, because we don't get into a lot of exacts for us. If they ask for 13 green light cameras, we would download 13 locations. We would download that to process that for them. And if we're asked to do anything above the normal processing of video, any kind of clarification work, then that would be a separate request so that we can show original compared to what was clarified. So that there's no manipulation of the video other than a clarification.
Thank you. I have no further questions, sir.
Nothing as to that.
Thank you, sir.
Yes, Your Honor. Have a great day, sir.
You too. You have the witnesses for the meeting?
I have no other witnesses, Your Honor.
Witnesses for the
No witnesses.
meeting?
Judge, at this time, I would move for a bind over as charged on all counts. I do have a copy of some of the paper exhibits, in fact, all the paper exhibits that were admitted today for the court of life. Just make sure we saw here. May I approach him?
Yes.
So just briefly, Judge, we heard testimony from Officer Branch that he was tasked out to a location, Joy Road in Greenfield in the city of Detroit, County of Wayne, state of Michigan. He indicated that when he arrived at that location, he observed an individual who was later identified as Mr. Robert Lever, being loaded by medics to transport to the hospital. Indicated that he observed another individual who was involved in the accident. He spoke with that individual being Mr. Ron L. Batchelor. The defendant indicated that when he spoke with the defendant prior to the defendant's arrest, the defendant indicated that the victim, Mr. Robert Lever, had walked out in front of him. The exhibits that were admitted, primarily CR People's Exhibit 1, which shows that the death of Mr. Robert Lever was caused by the accident itself. People's Exhibit 2, the certified driving record, which indicates that Mr. Batchelor did not possess a valid driver's license on that day. In fact, Officer Branch testified that Mr. Batchelor never produced a driver's license on the day in question, again showing he did not possess one. People's Exhibit 3, the data master results from Sergeant Fitzpatrick, and I anticipate the defense is going to get up and tell you not to believe a data master test, to tell you that it's unreliable. We heard the testimony from Sergeant Fitzgerald. He is trained in the use of data master testing, that the data master itself verifies through blank tests that it is calibrated and ready to go, that it shows zeros on there. He testified that the sound it makes indicates when it is ready. And he testified that all of those proper procedures were followed in this case. We're looking at a probable cause, Judge. If the defense counsel wants to file motions as to the sufficiency or reliability of a data master test showing your client at 8.26, she's free to do that. But this isn't even a close call on operating while intoxicated. This isn't a 0.10, 0.19, this is over triple the limit. Not 0.08, not 0.16, not even 0.24, 0.26. Defense, as I anticipated, is going to tell the court that you shouldn't believe the results of that this data mastery test just happened to show that defendant was more than triple the legal limit. I find that hard to believe, Judge. The testimony from Sergeant Warner was that he arrived on the scene. It's People's Exhibit 4 and 5. Now, the court watched the video, People's 7, and admittedly the video is a little bit dark. It's kind of hard to tell what's going on. But if you look at People's 5, you can see that white building. We see where the victim, Mr. Lever, is crossing the street. You can see those rumble strips right where Mr. Lever walked by, indicating, as Sergeant Warner testified, that an unmarked crosswalk is, indicating that pedestrians are going to cross at that location. We also see that there's a sort of turn lane, not a foot travel lane, and as you watch the video, Judge, you can see that the victim is standing in a turn lane when he's hit by defendant. Defendant never even saw the victim. He didn't see him because he's a 0.26. We know he didn't see him because he never touched his brakes. That's People's Exhibit 7 or Exhibit 6. Not once, not 2.5 seconds, 2 seconds, 1.5 seconds, half a second, none of it. He never touches brakes because he's drunk. He's operating while intoxicated. He's above that legal limit. He has a suspended license. The people have met their burden of proving this case beyond reasonable doubt, and for that reason, Your Honor, I'd ask the court to move the find over.
Your Honor, defense objects to the bind over for several reasons. And first, I would like to address my client's statements because defense does believe that these statements should be suppressed because he was not Francis Miranda rights and he was subjected to custodial interrogation. I would like to take both of these statements in turn because there are 2 points in which police interview my client. The first is when Officer Branch initially approaches Mr. Batchelor. Of course, as this court is aware, for determining whether a client is in custody, the question is whether a reasonable person would think they were free to leave. Not whether officers think they're free to leave, but whether the person themselves does. And the answer here is no. Officer Branch testified that their guns were drawn, that eventually multiple units arrived, and that traffic was blocked off.
Judge, that guns were drawn, that was never the testimony.
I don't recall that.
I apologize, Your Honor, not guns drawn, but they were armed. I apologize for that. They were armed.
That's a big difference.
I misspoke, Your Honor. Okay. But it is fair to say that Officer Branch did testify that a criminal investigation was underway. They were investigating this crash. So 2 officers were standing with my client, and then the inquiry turns into whether he was subjected to interrogation. The question that was asked was what happened, and a response was elicited, were you the driver? So the officer did testify that question, while not by him, was asked by the other officer on scene. Both of those questions are likely to elicit incriminating responses as they go to the operational element and causation element of OWI death. So that's the first. We believe that the responses to those questions should be suppressed. In the second instance, there's no question, Your Honor. Officer Branch testified that my client was handcuffed, he was already detained, and he was placed in the back of a police cruiser. So they get him out of the vehicle. And in this scene, he is in custody. The question here during this interaction was, were you drinking? And response was elicited. Based on that response, Officer Branch testified that he told my client that he was going to take him down to DDC for a breathalyzer. So we can assume that that question was inherently incriminating. And that goes to also People versus Kelly is very clear. The Michigan Supreme Court says you don't have to be under formal arrest. You just have to be detained in handcuffs in order for Miranda warnings to be read. And they were not read in this instance at any point. So all of those statements should be suppressed. Moving on to the elements, Your Honor.
Well, except for the officer testified that the reason he was placed in handcuffs was because he couldn't produce a valid driver's license.
We're not contesting that, Your Honor.
Okay, so
Not
they had
contesting that.
probable cause to arrest.
But detained still, that requires Miranda warnings. People versus Kelly makes very clear if you're in handcuffs and under arrest.
They also indicated, officer also indicated that he was under arrest for operating without a license and this person was injured as a result of the accident. He also suspected that he had been drinking. So let's say, and I agree with you, let's say the alleged admissions that the defendant gave about being involved or drinking or whatever the case may be, the officer had reasonable suspicion to believe that the defendant had been drinking. He said that was based on his observations of the defendant, even though he neglected to believe that in his police report. I submit to you that would be a question of fact determined by the trier if they believe that testimony.
Your Honor, if I can, I would like to address that specifically about some of those observations of reasonable suspicion. So for arrest.
And he wanted to give your client a breathalyzer at the scene that your client allegedly refused.
Well, that's his right, Your Honor. That's a right. He was issued a citation for that, but that is his right. But I would like to talk about the probable cause for the arrest as well, if that's all right. I know Your Honor referenced reasonable suspicion.
You got probable cause because he didn't have a driver's license that was involved in an accident. That's probable cause for arrest right there.
Understood, Your Honor, but on the statement itself, if they said he was under arrest and he was handcuffed, that is custodial interrogation that requires parameters. So regardless of what the reason was for that, I'm still requesting that those statements be suppressed, and I'm happy to move on at this point on that issue. Yes. I would like to talk about the operational element, which is element 1 of OWI death. There is no witness that testified today that personally observed Mr. Batchelor behind the wheel. While officers may, of course, look to reasonable suspicion or probable cause, there's no personal testimony about who was operating the vehicle and whether it was Mr. Batchelor. So I do bring that up. We did see the green light video multiple times. And as that officer testified, it is, and I think it's the court could see as well, there's no way to determine the license plate based on what we saw today, who was driving the car.
Let me interrupt just for a second. People, how do you place the defendant behind the wheel?
Well, Judge, the people would contest, first, that he's still on the scene next to a vehicle that was just involved in an auto accident. The officer testified that he's leaning against the tree because couldn't stand. He indicates that the individual had watery eyes, signs of intoxication, and he also made statements indicating that.
My question was, how do you place it behind the wheel?
Right, Judge.
About his statement.
Which statement is the court referring to?
The statement that he said that he was a driver.
So the statement that I'm referring to is the first one when the officer arrives and he says, I believe the question asked of the witness was, did you speak with the defendant? Did you ask him what his version of events was? He indicated that the defendant said that the victim had just walked out the street ready to run. You don't do that if you're the passenger in the vehicle. I think that's sort of first person narrative.
So I think the defense is saying though is that at that time the defendant was in custody and was being interrogated by the officer.
And I, Judge, not only do I disagree with that, case law disagrees with that. The testimony of the witness is that at that point, the witness was, the defendant was not in handcuffs, he was not under arrest. While he wasn't free to leave, that's reasonable suspicion, not probable cause for an arrest. So at the time that they asked him the first question, he's not arrested. Detained, sure, but not arrested. And reasonable suspicion does not require, Terry stops based on reasonable suspicion of detainment do not require Miranda warnings. When the arrest and things associated with one arrest, such as handcuffs, being placed in the back of a cop car, none of which are present in this case.
Your Honor, if I may. So it is uncontested based on the testimony and what the prosecutor is saying that Mr. Batchelor was detained. And the inquiry for custodial interrogation is whether a reasonable person would think they are free to leave. And Officer Branch also testified that he didn't think Mr. Batchelor was free to leave. So how did Mr. Batchelor think he was free to leave? And I think based on the indicia of the circumstances that we drew out on cross-examination, they were conducting a criminal investigation. 2 police officers were talking to him. The traffic was closed off at this point. Mr. Batchelor is there. It is fair to say that he did not think he was free to leave because he wasn't. And so he should have been subjected to Miranda under People versus Kelly, which says that.
So as it relates to your argument, the street is blocked off, nobody is there but the defendant, this car and the police officers.
I didn't say nobody else was there,
You did say
Your
that, I
Honor.
just heard.
I said that the traffic was blocked off.
Well, okay, traffic blocked off. I haven't heard any testimony about anybody being there aside from your client. So I'm thinking, even if I was to suppress the alleged statement that he gave saying that he was the driver of the vehicle, that I make a rational inference based on the totality of the circumstances. Him being at the scene of the accident, stayed there under this condition that the officer testified that he's under, that he was in fact the driver of the vehicle.
Is that a question, Your Honor?
I think I can. Might have been rhetorical. I think I can. But I'm siding with you in that the officer, and I'm not sure what the heck this officer was thinking about. Maybe that's why he's not with DPD anymore. I don't know, but didn't list pertinent facts in his police report. He did Mirandize the defendant after putting him in custody and then interrogating him. He made mistake after mistake after mistake. So even if I throw out the alleged statements that your client made, I think we still have enough to say that your client, based on the totality of the circumstances, may have been the driver of this vehicle.
Understood, Your Honor, and I would like to address some of that testimony, if I may.
Okay.
So as Officer Branch testified, he said that this was possibly his first OWI investigation. It was very early on in that. And I think that's relevant, Your Honor, because it goes to whether or not he was able to detect certain indicia of impairment here in order to
I
reach
don't
a
think
certain
you have to be a
conclusion.
police officer to do that. I can tell when somebody's drunk. I have to serve one young force.
That's true, Your Honor, but I guess it was the same question the court asked, and why was that not noted? It wasn't.
Rookie mistake.
He also said he had no independent recollection.
Either it's a rookie mistake or he's lying, one of the two. Either or, you're still talking about the same thing. I'm suppressing the alleged statement that he gave. But even after that, even if the statement is suppressed, doesn't mean the case is dismissed.
Understood, Judge. Understood. I would like to address the admissibility of the data master, if that is all right, just to make a record. I understand your ruling. But I renew my objection of the admissibility of the data master BAC report. And this is relevant because the BAC is another element of both.
So that goes as to what weight the court should attribute, not its admissibility.
Respectfully, Your Honor, I disagree as to weight and not admissibility. People versus Krulikowski, and I'm happy to give the citation as well, outlines foundational requirements for admissibility when it comes to scientific tests. So it's not to the weight, it's to whether or not it can be admitted. And
Is this
here,
the only test that we have that we're dealing with?
the only test,
The data master is the only, is that the only?
scientific test, yes.
So we don't have anything else.
Now that's been admitted into evidence right now, Your Honor.
And people, you can see that this test is no longer in use by DPD because of this.
I'm not going to see that, Judge. There's been no testimony as to that when it comes to questions.
The officer testified that it's not being used by DPD.
Judge, and again, the witness also testified that he is the one who maintains these things. He doesn't do the logs that defense is.
I get that, but that was the question. The question was, is it maintained? Was it used by DPD anymore? He said no.
Judge, I have no personal knowledge over that. I can't say.
Your Honor would like to revisit that testimony, and he did say that he was aware that there was an investigation over inaccurate test results. He said he also was aware that this specific model, the Data Master DMT, was removed from DDC, where this test was administered around the same time frame, 2020 to 2021. I do believe that's relevant. While I do concede that there were some elements of the foundational test that were met under Krulikowski, the important thing we didn't get today, Your Honor, was reliability. And this officer testified that he could not speak as to whether or not the machine was actively tested for accuracy before the test was administered. Calibration, that's a different story, although he admitted that he relies on the machine to tell him what to do. I won't go down that path, but I would like to say that he knows that it has to be accurate, tested for accuracy, he could not say when. And the prosecution has not brought that witness to say this was tested accurately, within the week time period that it's supposed to be. So I object to the admissibility of those test results, since those are the only test results that show VAC, and that is an essential element of this charge. Finally, Your Honor, very briefly, I would like to address proximate cause. If the court for some reason does allow these statements to come in from Mr. Batchelor, I think it's relevant that there was no crosswalk seen in that video. The officer who testified on the stand today said he can't speak as to whether there was a pedestrian that crossed, and I understand there's a question of fact. I did want to make a record of that.
Not only that, I mean, the client is allegedly operating a motor vehicle over 3 times the amount of alcohol is supposed to be in the system.
Allegedly, Your Honor.
And he's driving without a license. Shouldn't have been on the roadway to, again, hits and kills a pedestrian. And if I'm not mistaken, I think this is his 3rd offense felony. Or is that operating while intoxicated 3 times?
That the records were part of the exhibits, Your Honor. But what we're talking about here, again, is the testimony about whether or not there was a crosswalk. I just want to highlight that as well. There's also no testimony as to whether my
What I'm
client
saying is I don't think we have an issue of proximate cause here.
Understood, Your Honor.
But not for the defendant driving in the first place, let alone driving for the 3rd time under the influence. This would have never happened.
There was also no testimony that my client was speeding, Your Honor. He was traveling at 38 miles per hour. It was also, based on the testimony, very dark in this area, but I understand where you're going, Your Honor. But for all of the reasons I cited beforehand, defense objects to the finding.
So people, you have no blood draws, anything like that. The only thing you have is this thing that, and I do recall there being an issue with this data master test and it being abandoned by DPD as well as other departments. That's the only thing that we have that measures the blood alcohol content.
The data master test in this case, yes, Judge. I would note to the court that there has been no testimony as to any, as it relates to sort of the effect of this supposed change from the data master to another system. Your Honor might have knowledge over news articles. Those aren't taken as judicial notice. We're dealing with probable cause. We're also dealing with more than triple the legal limit. I think, Judge, if I came here today,
If it's accurate.
If I came
to argue.
Well, Judge, if it's reliable enough for probable cause, that's I think the question before the court. I think if we have a close call of 0.08, even 0.09, no signs of intoxication, no accident, maybe defendant breaks even in a CDR, but every single sign shows that he's intoxicated. We don't look at the data master in a vacuum. I think we look at it in conjunction with all the other evidence. Every piece of evidence shows that the defendant was intoxicated on that day in question and is bolstered by the data master test. Again, more than triple the legal limit. I think if I came to the court and said 0.09, there's this data master issue, I could see the court saying, I don't believe he's over the legal limit. I don't think this is reliable enough to say between 0.02 on the BAC. I think the court could reasonably find that. But to say that the data master is so wholly inaccurate that it shows more than triple the legal limit, that I think isn't a reasonable conclusion based on the evidence. And I would like to say one thing. Defense has harped a lot on this statement. She confuses the legal standards for what triggers Miranda. Free to leave is not the standard. Arrest is the standard for Miranda. Every traffic stop, an individual is not free to leave the scene, yet Miranda warnings are not triggered. Members of the 36th District Court have ruled in that way before, and the Court of Appeals has repeatedly overturned those and remanded with instructions to bind over, but admittedly not this court. But reasonable suspicion stops, which are the standard of a reasonable person would not feel free to leave, does not trigger Miranda warnings. It's formal arrest.
Let me have you guys approach for a second. So
I think it's an issue. I this is an issue a couple of it's best addressed. Judge, I'll just say that it's about explanations, how that work, which is shows the presence of archives, the existence of training, reliable, respected, reliable. What is it? This is the post call. This is a, you know, I believe.
Yes.
Travel. Every piece of it shows.
Okay, we had a spirited sidebar discussion. Let me commend both attorneys. You guys both did a very fine job. This court, in looking at the totality of the circumstances, I am satisfied that the burden of probable cause as relates to the charges contained in plaintiff one. I fully understand that's counsel's argument about the reliability of this data master machine, but taking that in conjunction with all the other surrounding circumstances in this case, the improper lane of travel, the non-braking, The CBR indicated alleged behavior of the defendant at the scene, the observations of him and the like, all point to the fact that he was most likely intoxicated at the time. So the court is satisfied that people have met their burden of probable cause as it relates to the charges contained in complaint one. The court finds those charges were committed in the city of Detroit. The court finds probable cause to believe this defendant committed. Now, I must say that when I looked at these charges, and then when I heard what the alleged blood alcohol content was, 3 times over the legal limit, over 3 times over the legal limit. And I looked at his bond, and his bond shows $200,000 personal. Now, I don't even see a tether attached to this. You see on the tether? Not even an alcohol tether?
No, Judge, and I was gonna address that with the court today.
Your Honor, if I may. I don't believe that's necessary, Your Honor. First of all, I would like to address the fact that this case is from 2021, it was 3 years ago. Based on the records that I have before me, Mr. Batchelor has not committed any other alleged driving offenses in the interim between 2021 and 2020.
That doesn't mean it didn't happen, just means it didn't get caught.
But that's what we have evidence of, Your Honor. That's what we can rely on.
Well, the evidence I have is that this is his 3rd offense notice. Drunk driving, and this time around someone died. That's a problem. If he was to walk out those doors and decide to drink and get behind the wheel again and hurt somebody else or hurt himself, what do you think everybody's gonna be looking at? This was this guy's 4th drunk driving. What are they doing down there in 36th District Court? No, not gonna happen. Quite frankly, he should be in jail if these allegations are true. But at a bare minimum, he should be on an alcohol test. So this court is going to place the defendant on an alcohol test. I'll continue on with an alcohol test. His arraignment on the information date is going to be August 8th, 2024 at 9:00 a.m.
Judge, is that an in custody tether or out of custody?
In custody.
In custody?
Yes.
1, 2. You would give brother and friend there. All right, follow me. I'll see that video with you. Ain't touched that one. No, you're not. It'll probably be about 5 days, up to 10 days, probably.
It takes 5 days to put me on.
For the tethers. Lately, it's been taking up to 5 days, sometimes 10 days, they're so back up. But he might get lucky.
Exhibits.
Yeah. I don't think that's actually mine there.
It's not doing.
They're just copies. Yeah, those are copies that I gave the court.
You have some copies there.
Good afternoon.
Where are both of you guys from? Where you been? How long have you been partners?
About since September.
Really? Outstanding. How about you?
December of 21.
You guys are very, very good.
Thank you.
Very good. Very good.
You learn quick when you come up from COVID times. Yeah, yeah, that was.
Oh, okay.
Yeah, you heard that.
You did very, very well.
Thanks, Judge. I can never cut out from the other, I'll leave here though.
No, man.
Judge, enjoy the rest of your day and have a great weekend.
Thank you, you as well.
This is AOI that was on the eighth, right?
Yes.
And you had a 200,000 person?
Yeah. All right, have a good day. Thank you. Well, that concludes the docket for today, folks. Hope to see you tomorrow, same bat station, same bat time. Have a good day.
So. Yeah, I got one coming down. If you guys find it quick, so I'm just waiting for paperwork. Yeah. Just tell them, now wait till, wait. Yeah, wait. Not waiting for the paperwork.